Hearing. Members of the public at this time, please take a moment to turn off or otherwise silence your cell phones and devices so that the board can hear the cases without interruption. For these public hearings, the board reviews the correspondence submitted in support of and opposition to these cases. The board also reviews correspondence and recommendations from other government agencies in preparation for the hearings. In today's hearings, staff will present the site plans, maps, photographs, and other documents that comprise the case record. At the conclusion of the staff presentation, the appellant will present his or her case to the board. After the appellant's presentation, the board will hear from those wishing to speak in support of the appeal. If the appeal has opposition, the board will then hear from those parties. After the opposition presents its testimony, the appellant will have a period for rebuttal. According to the BZA rules, the appellant has 5 minutes for presentation if no opposition is present. In contested cases, the BZA rules allow 10 minutes for each side to present testimony. Should the appellant wish to provide rebuttal testimony, the appellant should reserve some portion of the allotted 10 minutes. At the conclusion of each hearing, the board will deliberate and then vote on that case. The board is vested with the power to act on these cases under the provisions of the Metro Zoning Code, Section 1740-180. All section numbers that we refer to come from the Metro Zoning Code, which applies to the entire jurisdiction of the metropolitan government. The Zoning Code was adopted by the Metro Council and became effective on January 1st, 1998. I will introduce the entire Zoning Code and make it a part of today's record. The Metro Code requires a record of these proceedings. Because BZA meetings are recorded for the Metro Nashville network, it's imperative that anyone addressing the board please come forward to the front table and speak into the microphone. All speakers should identify themselves by name and address and then make the desired presentation. The Metro Code requires 4 members of our 7-member board to establish a quorum. The code also requires at least 4 affirmative votes to grant an appeal. In the event that 5 or more members are present but the appeal fails to receive 4 affirmative votes, the case will remain on the board's agenda for the next 30 days. Applications that fail to receive 4 affirmative votes within 30 days of the public hearing will be deemed denied by operation of law. Pursuant to board rules, an aggrieved party may appeal board decisions to Chancery or Circuit Court within 60 days of the entry of the BZA order. Additionally, as per the BZA rules, an aggrieved party may file a motion for rehearing at the BZA within 60 days of the original hearing date. After that time elapses, the board's decision becomes final, and no further action can be taken. If your appeal is granted, you're required to obtain the permit for which you applied. A permit must be obtained within 2 years for board approval to remain valid. It should also be noted that if false or misleading testimony is presented to the board, any board approval could be revoked at a later time by means of a show cause hearing before the BZA. Mr. Chairman, I submit that all cases have been filed in proper order, all appellants have been notified by certified mail, and all legal notice requirements have been fulfilled. I do have an announcement regarding 2 cases that have been deferred. First, case 2019-388 has been deferred to October 17th. And case 2019-422 has also been deferred to October 17th. For members of the public, our board utilizes a consent agenda at each of its meetings. 1 board member reviews the record for each case prior to the hearing and identifies those cases which meet the criteria for the requested action by the appellant. If the reviewing board member determines that testimony in the case would not alter the material facts in any substantial way, the case is then recommended to the board for approval. We'll enter into the record those cases that have been so recommended. If anyone is in here in opposition to one of these cases, please identify yourself, raise your hand, make sure I see you so we can pull it off the consent agenda and hear it in its regular order. Please note that on any sidewalk case that is placed on the consent agenda, the applicant has agreed to the recommendations made by the Planning Department. Mr. Chairman, these are the cases that have been recommended for the consent agenda. First, case 2019-389 involving property at 1924 Welsenboro Circle. This is a variance request involving a covered deck. The applicant has agreed to the condition that the deck is not to be enclosed. Is there anyone here in opposition to case 389? Seeing none, the next case is 2019-420 involving property at 3815 Hillsborough Pike. Is there anyone here in opposition to case 420? Yes, we'll pull that one off of the consent agenda and hear it.
And just, I don't know if you announced, but in any sidewalk case, any sidewalk variance case, that is on the consent agenda is only on the consent agenda because they have explicitly agreed to the planning department's recommendations. So if you oppose the variance on sidewalks, but you agree with what planning has recommended, or if you want to talk after this about what is recommended, then please do so. If you still have objections, that's perfectly acceptable, and we'll pull it and hear it. But I just wanted to make sure everybody knew that if you're a sidewalk case on the consent agenda, you have agreed to planning department's recommendation.
So we'll pull case 420 from the consent agenda. Next case is case 2019-430 involving property at 3826 Charlotte Avenue. Is there anyone here in opposition to case 430? Seeing none, next case 2019-437 involving property at 5304 Charlotte Avenue. Is there anyone here in opposition to case 437? Next case 2019-438 involving property at 901 12th Avenue South. Is there anyone here in opposition to case 438? Seeing none, next case 2019-441 involving property at 4483 Heath Road. Is there anyone here? Yes, so we will pull that one from the consent agenda. Next case 2019-443 involving property at 0 Nolensville Pike. Is there anyone here in opposition to case 443? Seeing none, the last case recommended for the consent agenda is case 2019-446 involving property at 2804 Lakeside Meadows Circle. This is another setback variance for a deck. The applicant has agreed that it will not be enclosed. Is there anyone here in opposition to case 446? Seeing none, to review, Mr. Chairman, the cases that are on the consent agenda are as follows. Case 2019-389, 2019-430, 437, 438, 443, and 446. Would solicit a vote.
All right, we have a motion for those cases to be on the consent agenda. Is there a second? Got a second? Any discussion? All in favor, say aye. Any opposed? That consent agenda passes.
Members of the public, if your case was just approved on the consent agenda, you are free to go. Please give our staff until Monday to process all the documentation associated with your appeal, at which point you can come into the office to obtain the permit for which you have applied. Mr. Chairman, before we move on to the cases to be heard, we'd like to take this opportunity to recognize any elected officials who are here in attendance. I will call on the council members that I see. For any newly elected council members whom I have not met, I apologize if I'm overlooking you. Please make sure I see you, and we'd love to give you the opportunity to speak now or at the time of your hearing if you prefer. Council Member Gamble, would you like to speak now?
Good afternoon, members of the Board of Zoning Appeals. Thank you for your service.
Welcome.
Thank you for this opportunity to speak. I'm Jennifer Gamble, the newly elected council member for District 3, and I am speaking on behalf of case 2019-350. I became involved with this case shortly after being elected on October 1st, and I've met with members of the Creek Trail or neighbors in the Creek Trail subdivision, as well as the property owner, Mr. Randy Yard, on several occasions, separately as well as together, in an effort to try to garner a compromise on the variance request for this case. However, unfortunately, after these several meetings, a compromise has not been met. The sticking points, particularly on the case for the variance, or the variance on the setback, is that Mr. Yard has not effectively communicated an acceptable hardship for the variance. Most of the homes in that subdivision have 60-foot variances, anywhere between 50 and 60-foot variances, and it's very hilly. It's a very nice neighborhood, very nice large homes, and the design plan of Mr. Yard would be very different from the current character of the community, and he hasn't, like I said, expressed an acceptable hardship as to why he needs to bring his home. He's requesting, I think, a 32-foot variance, which would be less than half of what the current variances are on the homes in the area. Also, a sticking point is that he has alluded to a 15% grade slope requirement that we haven't been able to find any information on. From what I understand, I think that may have been a requirement in previous zoning rules for regulations, subdivision regulations, but that's no longer the case. And so he can look at a higher percentage grade slope on his driveway than what he's suggesting. So because of those reasons, I am standing with the Creek Trail community in opposition of the variance request for this case.
And thank you. And I think we heard this case maybe 6 months ago, and the applicant's allowed to bring back a case after 6 months. And we didn't pass a variance at that point. There was some question as to whether or not his lot was steeper than other lots. And I guess from your experience, is it radically steeper? I mean, you've already said you don't see a hardship, so I'm assuming that you don't see.
Yes, and I'm not an engineer, but in just looking at it, eyeballing it, it's not any more steep than a lot of the homes in the subdivision. Homes on both sides of the property have very steep driveways, very steep driveways, and then there are some other homes that are closer, not to the extent of his 32-foot variance, but that are closer to the street. However, like I said, if there was a hardship that would explain why he would need to move that, then that would be considered. But most of the homes in that area have very steep slopes, just like Mr. Yard.
Okay, thank you. Are there any questions for the council lady? Thank you. Well, congratulations on your
Thank
election.
you.
And thank you for being here.
Thank you.
Council Lady Benedict, would you like to address the board now, or? I don't have anything to address. Okay. Are you here? Are you a council person? Are you with her? Would you like, I'm sorry, would you like to? I thought so, but I wanted to make sure.
That's this way, all right. Find my page, okay. Good afternoon, board members. My name is Quante Toombs, Metro Councilwoman for District 2, and I am here in regard to case 2019-435 in regard to a property located at 430 Haney Avenue. I've gone out to, and it's the request for a variance. The property owner doesn't want to build a sidewalk or pay into the sidewalk fund. I've gone out to the street. It's a small little residential street with about 4 or 5 homes that are currently occupied. And the property where the construction is going on, there is a steep drop from the road, so it's probably not possible to do a sidewalk as would normally be required. So I'm okay with there not being a sidewalk built. However, I would like the property owner to pay something into the sidewalk fund. I know there's currently about a $50,000 fee, and the property owner has stated that when he got his financing, he was not aware that there was going to be sidewalks needed, and thus the potential for a sidewalk fee, and that's a substantial fee. I agree that $50,000 is a substantial fee, but the project is a $1.7 million project, so I think that there should be something paid into the fund. But given the circumstances, I could understand that, having a $50,000 fee come out of nowhere, so to speak, would be a difficulty for someone who's working on a project and has already allocated where monies are supposed to go. And I don't know what the law is as far as having some type of variation on that fee, but if there is some type of wiggle room for the board, I'm fine with that, but I do want him to pay something.
And I think you all may be aware too that we're in that gray area between the new sidewalk law and the waiver process going into effect. And so some of these that are in this situation where their support for something reduced the board may decide to talk with the zoning administrator in our meeting to say, well, if this were in the waiver process, how might that go? And, because I know if they withdrew the case now, it might take them 3 or 4 more weeks to go through the waiver process. It could save them some time, but so the board may or may not be amenable to it, but I know they have the opportunity to go back and negotiate it if they choose to, or and that's what that process was meant to do, was to say, well, hey, in this case, it's not quite applicable. So hopefully we'll get to a good resolution for everybody on that one.
I hope so.
Well, again, and congratulations
Thank you.
to you, and thank you for being here.
Thank you, Council Lady Toombs. Is there any, I didn't see any other council members. Are there any others that I have not seen or? She already spoke. All right, absent any other announcements, then, Mr. Chairman, I believe we're ready to proceed with the cases to be heard.
All right, first case.
First case for the board to hear today is case 2019-365 involving property at 87 Vaden Drive. This is a request for a variance from the building coverage for an accessory structure. Zoning here shows you the zoning of the property is RS10. Aerial photography showing you this property and the surrounding area. Site plan submitted by the applicant is before you now, and finally, the current conditions of the property is taken on a recent site visit. Is there anyone here in opposition to case 365? Seeing none, the applicant will have 5 minutes. Please be sure to identify yourself by name and address.
There you go. To appeal this, where I could build this garage in my backyard. I'm not a lawyer and don't really know what to do here, but I've got some pictures that y'all asked to bring.
Yeah, and that's fine. And we've heard, I don't know if everybody on the board was here when you came before and had talked about this case, and I think that we had deferred it so that we could understand better what could actually be built on this property. And specifically, I think that we were struggling with the hardship of having a a second detached dwelling on or building on the property. And I think you had stated at the last case that you could build exactly what you wanted if you attached it to your house. And so I think what we were trying to figure out was get a little bit more information if that's right. So I know that, Emily, did we discover, did you all discover anything?
So this case was deferred at the last hearing for us to determine what would be allowed in terms of square footage if the garage were to be attached to the home. And after reviewing it, it was determined that the garage could be up to 3,000 square feet. It's limited 40% of the lot area for all the structures, but based on the calculations that staff did, it was 3,000 square feet.
So the applicant could build what the applicant wants to build if it were attached to the.
Correct.
Okay.
Up to that amount, he's got an existing, right?
He's got existing structures, I think because it's attached, that's what makes a difference. And of course, he could only do that if he meets the other bulk regs, setback, and others. So that, yes, that's a maximum.
Pardon?
Can we see your photos?
Did you have anything to add while we're looking at the photos?
No, sir, just trying to get this garage built where I can store my daddy's cars.
Right. And then tell us again why you don't want to attach the garage to the house.
I can't attach it because, well, I've got some pictures of going across my hot tub and I got a little pond there that's.
Okay.
I'm not wanting to put any water or electricity or anything in this garage. I'm just trying to restore some old cars and keep them in there. And I take them to car shows, and these A models, I let these little kids ride in it, and sometimes they don't get to see stuff like that before.
Is it being constructed now, or is it?
That's my swimming pool part.
I guess I see something that looks like concrete block. Is that on the garage now, or?
Yes, sir.
May I ask a question, Mr. Chairman? Have you already started demolition on some of the structure? I mean, that's what the pictures look like. That's, I guess,
I started and
and then you stopped?
stopped.
Okay.
Well, it also looks like the topography changes from where your deck and hot tub is to the bottom of the pool, which would be the floor of the new garage. Is that correct, too?
Yes, sir.
Okay.
Do you mind if he just stands up and tells us what each picture is? Because there are several structures, and I just want to make sure that we understand what we see.
Sure. Sir, if we're going to give you your photos back, and if you could just hold them up and just, because we've all seen them, but if you could hold them up and just say, hey, this is looking from, you have a point of reference on the screen, but just tell us exactly kind of what we're looking at.
Well, this picture right here is looking from the pool up to the top of the house where they wanted to put the breezeway.
And that's the one that shows an elevation difference, is that right?
Yes, sir. And this is actually the same picture, but looking from the top down to the pool. And that's just the pool that hadn't been cut out yet. Sir?
Which direction on the one with the pool, which part is it face? I'm trying to orient myself.
Okay,
in
it's
the
on
picture.
the bottom side of the pool.
Okay, down where that little blue, what's showing on ours, the blue little, looks like the pool house?
Yes, sir.
Okay, going up, okay.
Yes, sir.
Thank you.
Okay, so the wall here is the pool house.
Mm-hmm. And that's where I cut the frame, the pool out, and we're going back with concrete. And so, actually, the way the walls are, I only need to come up about 5 foot, 6 foot.
Did I understand correctly, you're going to use the existing walls of the pool as part of the walls for the garage?
Right.
And so that sets it as a structure a lot lower than for your neighbors and that kind of thing? Okay. Any other?
That's what I couldn't understand.
Yeah.
So you're actually going to go driving. So you're going to go driving down into.
No, I'll be driving flat straight across.
So you're going to fill up to.
Right.
Grade.
I'm coming from my shallow part to the deep part, and it'd be flat.
Okay.
And the shallow part's 6 foot deep.
Okay. Is there anything else you'd like to add?
I don't know of anything.
Okay. All right, we'll close the public hearing.
Well, I think I'm the one that suggested deferring
Yeah.
to get more information. So I guess what strikes me about this case is he is proposing to build where there already is an impervious surface, which is unlike some other cases that we hear. So he's proposing to put the garage where the existing pool is. And there is a grade change. And if the structure was detached, then it would be difficult to make the change from the house down to the garage. It'd be difficult to do that, I think. And so that's the reason why I was entertaining, the variance request to allow him to do it.
Well, and because if he had a breezeway connecting to the house, it would be permitted, and there is a topography hardship preventing that. And so are you making a motion?
Sure, I will make a motion to approve the variance request based on the topography of the site.
Got a motion, have a second. Any other discussion? All in favor, say aye. Any opposed? That motion passes. Good luck.
Thank you.
Next case.
Next case, 2019-350, involving property at 4136 Creek Trail Drive. This is a request for a variance from front setback requirements in order to construct a single-family residence. Before you is a zoning map showing you the zoning of the property is RS20. This is the aerial photography showing you the surrounding area. This is the site plan that was submitted by the applicant, and finally, the current conditions of the property.
Is the applicant here?
Randy Yard. I don't believe the applicant is here, Mr. Chairman, so it would be up to the board's discretion how to proceed.
How many, are there neighbors here in opposition to this case? There's a handful. Have any of you, just show
Mr.
your hands, have any of you seen Mr. Yard today?
Mr. Chairman, I just was advised that he emailed to our staff to confirm the location of the meeting, so it may be that he's.
Okay, then let's hear the next case. We may let this go one or two cases and then make a decision after that. But I don't want to have folks have to come back, but also don't want you to have to wait all afternoon on Mr. Yard either. So, but we'll at least hear the next case and then decide what to do about 350.
Next case, 2019-354, involving property at 2400 Nolensville Pike. This is a request for a variance from the fence height restrictions in order to maintain an existing fence. The board will likely recall that this case was deferred from a previous meeting. To give you a brief recap, this is a zoning map showing you the zoning of the property is CS. Aerial photography showing you the property and the surrounding area. This was the site plan that was submitted by the applicant. And finally, the photograph showing you the current conditions of the property. Is there anyone here in opposition to case 354? There is. So each side will have 10 minutes to make their desired presentation. The appellant, you will have 10 minutes. Be sure to reserve any rebuttal from this 10 minutes and identify yourself by name and address.
My name is Greg Atwood. My office address is 6953 Charlotte Pike, Suite 401, Nashville 37209. I represent the property owner, Hamid Rabi. Before us today is a variance request regarding the fence that was constructed at this property. Mr. Rabi approximately 20 months ago constructed a fence that's very similar to the fence he has at another location as a result of problems he had with theft and burglary at the location. He was having cars broken into. His business was broken into numerous times. At the time he constructed the fence, he did not realize that the rules had changed a few years back regarding specific restrictions for car dealers. And so as a result, he constructed a fence that would have complied if he was not involved in car sales, but now doesn't comply and is requesting a variance. We'd like to make a couple of modifications. One, we have discussed moving the corner of the fence back, the corner that's closest to the intersection. This is a really unusual intersection in that Peachtree Street comes in at an odd angle, and there's also a pretty significant elevation change between Austin Avenue and Nolensville Pike. And as a result, it is all the concerns from the property owners around have been regarding the visibility, and they're right. There is a significant problem with visibility. Quite frankly, I don't understand why right turn is even allowed there, even if there was nothing on that lot, because there are utility poles, and I think the utility poles are visible in the photographs, and I have some other photographs that I just took this week to pass around as well. But there are utility poles on the sidewalk that are really a huge obstruction to the view. We've talked to the owner of the Easy Money property that is across Peachtree Street. He's more than willing to have a traffic mirror placed there, if that would be possible, to allow people to see down Nolensville Road. What the property owner and I had talked about is essentially where you see the the vehicle on the map that is the closest to the intersection, his sign is just right in that area, and we would essentially be cutting about probably 8 to 10 feet off that corner area to allow for some better visibility.
Is there, when we deferred this case at the last meeting with the clear, I thought, direction that the consensus was that the fence was an illegal fence, and yet we were respectful of the concerns that the business owner addressed, as well as the safety concerns that the neighbors addressed, and we said, basically, go work with the neighbors, work with the council lady, or council person, I'm not sure who the council member is, and come back with a specific proposal. And I hear you say you're willing to make changes, but do you have is there
I did join and I thank the administrators of the 16th District Facebook page. They allowed me to join that page so that I could interact with some of the neighbors. There were a couple of different posts that were lengthy posts where people had added comments, and I have chimed in there. I had left my phone number, my email address.
Yeah, that's not my question. My question is, do you have a site plan now to show us exactly what this thing would look like? And is the council member has the latest,
And I just talked to of course, the council member was just elected.
I
I'm sorry.
appreciate it. I'm just not done with my question. The council member, or asked the question, I have not done with my statement. The council member, the letter that we have, which is an active letter since the last hearing, is that the council member is still opposed to this for safety concerns. And so do you have a site plan today that would give us some very specific, and the neighbors some very specific things to see?
I do not.
Okay.
The council member, of course, was just sworn in, I think, last week. I did see a letter that was sent yesterday. I've not had a chance to have any contact with the council member yet. I would like to, and quite frankly, had it not been for this falling during the middle of the elections, that would have been the first contact I would have made, would have been to the council member. I didn't want to go to an outgoing, just not knowing who I would be dealing with. We're happy to do so if the board would perhaps entertain us deferring this again to try to get a site plan and work with the new council member. I do know that the concerns revolve around visibility.
I guess the only question I would have, which tells you how I feel about it, is what compelling information do you have at this case that we didn't have at the last case that would cause a very skeptical board to change their minds and grant you a variance?
Well, I honestly, I wasn't here. I don't know what was conducted at the last meeting, unfortunately. But I've tried to speak to the neighbors as much as I can. I don't know that it had ever been raised, the issue with, I really wasn't aware of the issue with the utility poles. And I don't know that quite frankly, I don't know how much of an impact the fence itself has. There's still going to be cars sitting there whether there's a fence or not. I think taking it away from the very corner could certainly make an impact. I think some other means needs to be implemented, such as a mirror or something like that, in order to allow visibility down Nolensville Road. Even without the fence, there's almost no visibility for that intersection.
Okay.
Didn't we have some discussion about a dealership and a repair shop within a certain number?
That may have been another case. I mean, we're getting a lot of these fence cases because folks are turning in, the fences because it's become apparent that they're not legal fences, and so we have some council members and other folks that are trying to get
Yeah,
these
I do
legal.
remember we had a discussion that this was a nice fence, an expensive fence. Yeah.
Any questions for the applicant? Did you have anything more to add?
I did have some photographs
Sure,
to
that's
pass
fine.
around, some additional photographs if I could. what I primarily wanted to demonstrate, and these photographs are taken at much a similar angle to what we see here on the screen. Those utility poles that are right next to that are between the sidewalk and the street, it seems like those are the biggest hindrance here as far as visibility. Again, I understand the fence. I understand the fence doesn't comply, but I'm not sure there's any other means to prevent the crime that has been going on and that he has suffered from in the past. I'm certainly willing to, any ideas. I would welcome the opportunity to interact with the new council member to see if there's some agreement we could come to.
And, well, I think we should hear,
I was just going to say, is he requesting asking it again? I mean,
well, and I think that's up to us to decide. I mean, yes, it sounds. And I think at this point, because I think we need to hear from the opposition, and then we can decide if we want to defer. If that's acceptable. All right.
I'm as skeptical as you are, Mr.
Yeah, all right.
Chairman.
All right. Was there anything else you wanted to add at this point?
That's all I have.
Okay, you'll have 7 minutes and 14 seconds for rebuttal, and we'll hear from the opposition.
Good afternoon, Board.
Yeah, if you
My name
would
is-
press the button till the red light turns on. It's already on? I'm sorry, I
It was
can't
on.
see it.
Sorry. Good afternoon. My name is Phyllis Wilson. I live in the neighborhood. I spoke to you the last time that we had a meeting here regarding this issue. I also spoke with a person who identified himself as the attorney, but it wasn't this gentleman. At the end of the meeting, after you had indicated that he should meet with neighbors, and I suggested to him the Facebook page would be a way to connect with all of us and set up a meeting place in some place that might have a room that we could all come together and come up with a solution. I have stayed on top of this. I have spoken with people in codes. I've spoken with people at the police department regarding the different calls that they've had about this property, the
And
crime.
what did you learn from that?
They told me that they have calls, but the fence is locked, and once the alarm goes off, they're never able to get anyone to come and inspect the property. Having been in business before, I know that once the police are called, you either have to go or they're just going to mark it off, and I don't know, I guess you get a fine after so many. So because I've stayed in touch with it and with other people, our different neighborhood association presidents, no one has reached out to us to have a meeting. It is out of compliance. It is a problem. Yes, the road does have a very unusual corner. It's less than a 90-degree. But until this fence was erected, it wasn't as big a problem as it is. And having checked just in having to go through that area a few times recently, intentionally, I realized that there is a major problem, and it's a safety issue, and I, for one, will not turn right on red. That's a law that would have to be changed with parking or streets or whatever to say that you can't turn right on red. I do feel like that there has been a lack of communication on their part to come to us. I think it was mentioned the last time by the property owner that he could do a setback, and then he could just park a car on the corner instead. And one of the board members, I'm not sure which one, said, well, I would be careful about that. So it seemed to me from that remark that maybe there was some idea that maybe we could just get around this. And I think the neighbors, those of us who work and can't come to these meetings, are a little disturbed by the way that this has been approached. Questions?
Was there any other information that you learned, contacting the police and others that
I think there is a problem with, I learned a lot in this process. I had an appointment with someone in codes. I went to property standards, met with the police. I learned a lot about the new guidelines that were put in place a couple of years ago, but this was built after that. And I grant you, it is a beautiful fence. There's no one saying that this is an eyesore, but it needs to meet standards. And if that means that an alternative is across the front, we would lower the height of the fence across the front on the Nolensville Road side and cut the corner back so that there's not an obstruction for motorists. I think everyone would be in agreement with that.
Well,
but it needs to be presented to more than just me. I can't speak for the whole neighborhood.
How would you feel about a deferral?
I'm okay with a deferral, except that I feel like I'm a little bit conflicted because I don't feel like the appellant did what he was asked to do the last time, and that I struggle with that.
Sure.
Yeah, you know what I was going to tell you. That's exactly what I was going to tell you. That's my frustration. And, you know, I think this board, as long as I've been on this board, has worked really hard to try to come to compromises in situations like this. Because, you know, especially when we can at least empathize with both sides of the situation, and not the breaking of the rules side on his part, but the security issue, and yet there's an overwhelming safety concern that's been expressed by your council person and the letters, and I think that's real, and that trumps, frankly, the fence, but at least in that portion. But I thought we were clear on saying, you know, what we needed.
And that's why
and got you a
I went
second
out.
shot, and it seems like we're right back to where we started before. So I understand your frustration on that point.
Thank you.
Any other questions for? Thank you for being here. All right, now we'll have the applicant has 7 minutes and 14 seconds, I believe, for rebuttal.
I appreciate her being here today to express the views of the community. I apologize. I was under the impression that the interactions that I had made was sufficient, and I'm sorry if I was wrong about that. If you'll grant me a deferral, I'll be in contact with the new council member this afternoon to arrange somehow to get some sort of a meeting set up. We'll do it at their convenience. Whenever I'm told to be there, I'll be there. We would very much love to, you know, and it is a possibility. Perhaps we could look at lowering, you know, perhaps lowering height and then cutting off that corner as was just suggested. I think that's a great idea, and that's a great place to work towards. I would request that opportunity. I apologize if I've wasted your time today.
I might look a little more favorably if we've got an absolute deadline that they either have, they get together with the member, the council person, have their meeting, and when they come back, because we keep doing this and we can do this forever with all due respect, so.
Well, and I think we can maybe set that in our discussions too, if we choose to do it, and we may or may not. You know, I mean, I don't know. It really it seems deja vu all over again, as Yogi Berra says. Is there anything else that you'd like to add, or any other questions?
I'll add something. We need if we do vote for you to come back, we'll need something more concrete, a drawing or something in writing that lets us know definitively what the proposal is.
And I also think you should present that proposal to the neighborhood group. It sounds like the neighbor that's here today did a lot of groundwork to prepare for today's meeting, and I think, to be fair to them, whatever you guys come up with, you should present all the drawings to them so that they have more say.
I think, actually, that's a great point. I think probably the right course of action would be to have a meeting, get the input, come up with a plan, and then have a second meeting to go over that with them.
Anything else to?
And any hard deadline that you give me will follow.
All right, we will close the public hearing. Yeah, I mean, to me, I think there's two choices. Well, maybe Well, no, I think there's two. One is we can vote on the variance request today and allow the applicant to bring a proposal for another option at a later date. And the second option is to just defer this one last time. And I think if we, bringing another proposal means that you have to renotice it, tell everybody exactly what you're going to do. I think there's some advantages to that, and I think it would not require 6 months wait because it would be a different proposal. He's asking for a variance for this fence, and I think that, I don't know, is that?
That would be up to the board's discretion whether or not the application is
considered
different enough to be considered.
Well, and I mean, you know, my frustration is that we spend a lot of time on this case. We have a lot of other cases, and we were very explicit about it. I think anybody that reviewed the case or watched the case would have seen what we asked for. And it was frankly, it was to give an applicant who had an issue that we had empathy with, but not legal standing, a chance to go back and prove it, and there's just nothing that happened to do that. So that's my frustration with it. So I'll do what the board wants to do. But
I think we should defer it, but only if it benefits the opposition. And I think there may be some benefit to the opposition in meeting with this other neighbor and trying to work something out, because I'm the one that made the point last time. The fence can come down, and their concern is with the visibility. The fence can come down, but the cars can still be there, and I think there may be room to negotiate. So I think if there's a benefit to the opposition, then that's a reason to defer it. I don't think we should defer it because I think they have been dilatory in acting. The applicant has, and I understand there's good reasons for that, but still it happens. So,
And for disclosure purposes, I mean, I know Mr. Atwood from practicing law with him. He does the same type of law that I do. But we heard a proposal today that we didn't hear last time. And yeah, I did get the two of them confused, but we're now talking about reducing the fence. And my recollection, correct me if I'm wrong, was he wasn't going to even consider that. He wasn't even considering moving it. And I've heard both of those changes. Now, what I would like, though, is just a hard deadline. If we vote to defer it, and I'm not saying how I'll vote right now, obviously.
Yeah. Well, and that was clear, too, when we deferred it last time, was that the deferral itself shouldn't be taken as any implication that we will grant a variance. It's just giving you one last swing at the bat. So
Would like to have the new council member have an opportunity to weigh in on this.
But, yep. Is everyone in agreement with its deferral? Then if you don't mind, I'll ask the applicant if he prefers 2 weeks at the next meeting or the first week in November. And so if we were to defer this case, we can hear it in 2 weeks, or we can hear it the first meeting of November.
I would prefer the first, I'm sorry.
she's for it too.
Asking me?
Yeah, and ma'am, what were you saying, first week of November?
He's asking.
I think 4 weeks is better.
Okay, then first week of November.
That would be
Okay.
fine.
All right.
That gives us time to have 2 meetings.
All right, is it-
That's what I was going to make the condition, that they have 2 meetings, a meeting to get the feedback and then another meeting to present plans.
all right, so it sounds like that you're making a motion.
I was just joining your motion.
All right, so I'll move that we defer this case to the first meeting in November with the condition that at least 2 community meetings happen, one to gather facts, one to present a proposed plan, and that we will consider this case on the condition also that there's a site plan and very specific proposal on exactly what fence is going to happen, and that council member support and neighborhood support will also be looked upon favorably. And so I would suggest that you would achieve as much support there as you can before you bring it back?
Absolutely.
Is there that's my motion. Have a second? All in favor, say aye. Any opposed? All right. Next case.
Mr. Chairman,
Thank you.
the applicant for case 350 is here now, if you want to take that case up next.
Yeah, we'll hear 350.
Case 2019-350 involving property at 4136 Creek Trail Drive. This is a request for a variance from front setback requirements in order to construct a single-family residence. This is the zoning map showing the zoning of the property is RS20. Area photography showing you the surrounding area. Site plan, and finally photographs from a recent site visit. There is opposition present, so each side will have 10 minutes. Mr. Yard, please be sure to identify yourself by name and address, and also remember if you want to have a rebuttal period, that will come from your 10 minutes.
My name is Randy Yard. I live at 3456 Chandler Cove Way, Antioch, Tennessee. I purchased this lot in Creek Trail last October. I started clearing the lot in December after obtaining a building permit and a plot plan from Metro. Upon starting to clear the lot, I was contacted by my neighbors who told me that I was not meeting some neighborhood restrictions. I met with my neighbors and agreed to file appeal to change my plan, and was in here before you guys in February or March.
Yeah, now you never got a building permit because if you had a building permit, you wouldn't have to be here, right?
No, sir, I have a building permit.
What is that?
I assume he's applied for a building permit.
No, I have a building permit.
Did the building permit allow this setback that you're requesting?
No, that's
So
why I'm here for the
So
variance.
you want a different building permit with a different setback?
Yes. It was at the point that I met with my neighbors and found out that the building permit I had been given wasn't going to work, that I applied for the variance after meeting with them. We all agreed that the plan that I was going to build, I could not do. So with an agreement with my neighbors, I applied for the variance. I came, and then my neighborhood came and opposed the variance after we agreed that I would ask for it. Their reasons for that was that I was going to devalue their property values, and they felt that having a house that close was going to be a difference in the neighborhood. There are 3 or 4 houses that are at the same setback that I am. My hardship is the slope of my lot. My lot is about a 33% slope, which is twice the slope of some of my neighbors. And in meeting with my neighbors a few times, I have found out that they were able, when they built 20 years ago, they came in and graded off their hills and flattened out their lots and built their house. I was contacted and told there was a new council person. I met with her. She suggested another meeting with my neighbors that we had. In that meeting, it was decided that I agreed to meet with a home builder that lives in my neighborhood, and there's a guy that works for NEC, an engineer, John Richardson. I met with those guys. We went over my plan. I showed why I need to move forward. They agreed with me in that meeting, and there are some people that are still opposing my variance, and that would be how I would present the start.
And I don't know if you were here, but your council lady did come and testify that she didn't see, after meeting with you and the neighbors, she was hoping for an agreement. Said there wasn't an agreement made, and she didn't see the hardship, and from her perspective, didn't see the radically different slope in your lot than the other lots.
Okay. I can show that in the critical lot permit that it is required you do minimal grading and you do not do hardly any clearing of the lot. My lot at 33% is 100% steeper than my neighbors' lots that are at 16 and 14%. So that is a considerable hardship.
Is that the immediate next door neighbor?
That would be 2 neighbors it would be, I have one person that is 37 feet at 4144, and there's somebody at 42 feet at 4124. There are new codes that apply that my setback the original setback for the subdivision, the front setback was 30 feet. There's a new Metro building code that does not allow for that. You have to have an average of the 2 houses to your left and the 2 houses to your right. The first house to my right is set back 120 feet, which drives my setback considerably farther back. I have a flat spot in the front of my lot, and then my lot gets extremely steep going towards the back. I have done everything you suggested. I needed to redesign my house a little bit. I redesigned my house and put a garage in a basement so I could meet the building slope driveway, and did all the work that you suggested in the last meeting and met with my neighbors again, and I'm here again then, to present my case.
But you're still having, and I know there were a lot of issues that don't relate to this board in terms of the neighborhood covenants and front-loaded garages and all that kind of thing, and I know they were concerned about it.
Yeah.
But that's not something that's there are remedies for the neighborhood other than this board if what you're wanting to do is not in compliance there. But I guess when I remember it from 6 months ago, but I don't see a lot different. I mean, it seems to me like it's the same thing we heard. I know you've done a lot of work, you've met with a lot of people, and you met with your council lady,
Yes.
but I don't hear a lot that, when I look at it on paper, it looks like exactly what we saw 6 months ago.
What I've done on paper is I have left the footprint of the house the same so that I don't have to go back to a civil engineer and redraw the whole plot plan. I had a one-level house. I have now created a garage that's in the basement so that I can have a drive-under garage so that I can meet the slope of the driveway, at 15%. There's a lot of driveways in my neighborhood that are 30% and unusable. So why are
they unusable? If
it gets iced up, I've talked to some neighbors that when it gets icy, and so they can't even drive up their driveway. They have to park down at the bottom of the hill and walk to their house. And I would like to be able to use my driveway. It's my understanding from my civil engineer, it's not my personal knowledge, but my civil engineer said Metro has instated a maximum slope on driveways that was not in existence, 20, 25 years ago when they built their houses. Now, like I said, that's my civil engineer put that in a letter that I showed to the councilman and the people in the last meeting.
Any questions for the applicant? Anything else to add? All right,
I just would like to say there's nothing about my house. There are other variances that have been granted in the neighborhood to move to closer. The house that's at 37 feet was granted a variance so that he could move his house closer. There's 4 other houses in the neighborhood. They're opposing me saying the property value, that was a problem, and like you said, other issues. I had a building permit for a house that was 1,800 square feet, and they have a minimum square footage allowed in the neighborhood, and I've increased the square footage of my house to 2,600 square feet. They said they were concerned that I was going to get this permit and just build anyway. I think the fact that I stopped building completely from clearing the lot and have spent 8 months working with my neighbors and meeting councilmen, I have no intention of building. I work for a general contractor in town, Bakar Construction. I'm a project manager. I follow codes. I follow regulations. I've tried to meet with the neighbors. I've tried to compromise. I've gone to all the meetings they've asked for, and I'm not asking for anything that other people in the neighborhood have not been granted. The value of the house has increased, so that was the main concern of my neighbors, was that I was going to build this small house where there's all met a square footage, and I increased the square footage and told them I was willing to sign whatever was necessary to build a house that size.
All right, you'll have 5 minutes and 15 seconds for rebuttal, and we will hear from the opposition. And just, you collectively have 10 minutes, so if anybody else wants to speak, then it all comes out at the same time.
Thank you.
Sir, if you could introduce yourself and your address and tell us why you're here.
Okay, I'm Lorenzo Wright. I live at 101 McGanna Drive, about 5 doors down from where Mr. Yard is going to, from his lot. We just want to state very clearly and plainly that no one agreed to his meeting a couple of weeks ago when we met, a couple of Saturdays ago. I was there. I'm a general contractor, licensed general contractor. I also build houses. And the problem we had was that, one, we've never seen a plan of his house. We've only seen penciled drawings. And even the modifications to put a basement garage was only penciled in, and it was also drawn at a 45-degree angle on the lot to have a side entry garage. So it was not going to be able to parallel to the street. But if this is the street, he was going to build his house like this and have a driveway that slopes to the street. And that was totally unacceptable to the neighbors. We have nothing personal against Mr. Yard. One thing we do say, though, consistently is there's been a credibility issue. But I'm not really here to discuss that. The problem I have, and we have, is that his lot is no more critical than our other lots. The lot he just talked about where the house sits back over 100 feet, that lot is steeper than his lot. And they have a driveway that they do use. Now, if it snows and there's ice, most people don't go down the driveways here in the state of Tennessee. But if you're from Michigan, it's no big deal. So, you know, that's just Southerners, right? And I'm from the South, so I say that I'm with you on that. The other issue is, if you've seen his site plans, he's talking to you as if he's never going to do any excavating. He has to. He's only going to save 4 feet of slope by dropping it down 30 feet to the 30-foot setback. It's almost no difference if he has it back at 60 feet. He's acting as if the front of his 58-foot deep house is going to have a 20-foot drop on the front of it. If that's the case, then his garage would be at a grade like this inside the house. He has to excavate and level. Every foot that he drops the back of his house to level out his garage, he drops that severe slope on his house. So this difference in his slope, if you look at his engineered drawings, you'll see that it's not the severity that he's saying. So from just a builder standpoint, that is absolutely not true. Also, as a builder and someone that has as much experience as he has, and as a project manager, he picked a lot. He built the house. He picked the house. And everyone knows there's certain horses for certain courses. And this horse was not for this course. He should have never picked this particular plan for that house and that lot. He should have changed his plan. But as a builder, this should not have been a surprise to him after walking his lot when he bought the lot, that all of a sudden there was a problem. It just doesn't make sense. The houses he's talking about that are 30 feet setback, a couple of ones he's referring to are not in the covenant. If you look on the picture, there's a white house right in front of his, just a little bit to the right or right to the right of that marker there, that red marker. That house is not in the covenant. That house is closer to the street. The one he's referring to was built over 20 years ago. My house was built 13 years ago, and we had a 60-foot setback. We're further back because it made more sense, but our slope was severe too on Magana Drive, just about as severe as his. We had to do excavating and flip dirt and do what we had to do to level it off so that we would not be walking on a floor with a grade like this, or our garage would not be like that.
So you agree with the council lady, you don't see a unique hardship?
No unique hardship, and there's been no change from what he's done. He's only shown us 3 different site plans with penciled-in drawings to show his house at an angle and then set back at different places, but there's no difference in that. So we just don't see a difference. There's no difference from the last time we met.
And the observation that the plan is basically the same?
Yes.
Essentially the same as a view you share too?
Yes.
Any questions for the opposition?
Are there any other matters or any other folks here in opposition besides?
Yeah, if anybody else would like to speak to, sir, did you have anything else you wanted to add?
No, if there's no questions, no.
Okay.
Sorry, my leg fell asleep there for a second.
And if anybody else wants to speak too, you can come up and sit while this gentleman talks too.
My name is John Baker. I live at 4171 Creek Trail Drive, directly straight down from the marker on the opposite side of the street. I'd be the neighbor looking at this house if it was to be built. Like I said, we have met with Mr. Yard, and we do appreciate him trying to do that. The issue I have is specifically, Mr. Taylor, you had said last time, if you come before us again, show us something different. And I don't believe, as he had said, that there's anything different from before the last time to this time. And like he said, we're not in opposition in building. We're just in opposition at building here in that particular part of the lot. If he wants to give another plan where it's 60 foot back, we're fine with that. It's not that at all. But I just wanted to state that that was my frustration, is show us something different, show us something that it will work, and we'd be more than glad to work with them. That's all I really wanted to share.
Any questions? All right, thank you. Would anyone else like to speak? If not, then we will hear back from, yes, sir, come on. If you'll just press the button until the red light comes on. There you go. And state your name and address and tell us your thoughts.
My name is Calvin Owen. I live at 4150 Creek Trail Drive, which is about 3 houses down from where he's considering building. We've met with Mr. Yard, and so he said he's continued to show us the same thing, just turn it over different or put it on a different piece of paper. My house is 110 feet from the road, which I had to pay money to get it moved back. He just doesn't want to spend the money. He hadn't even cleared 30 feet back. And he keeps presenting the same plan to us every time he comes. And he just tells more lies about what he's trying to do to try to accommodate us. When we're trying to work with him by meeting with him, and met with the council lady, and I've been there every time he's come except for one. And he keeps throwing out lies about the neighbors and what they're saying. Nobody has agreed with him. And my neighbor right to my left over, her house is further back than mine, and her incline is even more so than mine. But they endured the hardship of the bulldozer work and the excavating work until they got what they tried to accomplish. And by him building his house 30 feet from the street, it's going to make a mess out of the whole neighborhood from his house down. And he wants to put rock and doesn't want to put brick. And it's just, I'm sorry, but it's a mess. I thank you. I appreciate your time.
And thank you. Any questions? Did anyone else want to speak? Anybody else? All right.
Hi, I'm Oscar Miller. I live at 4144, which is 2 lots over from Mr. Yard. I'm the one he is referring to who had a setback. And I want to point out that that was 20 years ago. I got all my neighbors' agreement, and I had a hardship. I had 2 large, very mature trees that were sitting on the back. I can't show you because they're gone now. What we've done is my lot has been graded 3 times since, the initial grading, and then 2 since we built to get it to where it's pleasant for us. So that's what people see now. But before, it was steeper. And so, but the reason we got the setback was because of the topography, and we had 2 large mature trees that were on the corners. And I just, we just loved those trees and wanted them to stay. Well, in the grading of the second one, one of them was covered with vines, and it never came back. And these were like, maybe like 3-4 feet in diameter. So it never really thrived. So we had to, because it was behind the house, we had to knock it down because we didn't want it to fall on the house. So it's different from the lot, from Mr. Yard's lot. And some of the other things that he's saying that we don't agree with is that I measured first of all, his initial plan that he submitted to the zoning board, the Board of Codes and Building Safety, has him with a 60-foot setback and a 14% slope on his driveway. What he's asking for now is a 32-foot, and then his driveway will be 15%, so it's worse. So it's just not making a lot of sense to us, and every time we talk to him, he mentioned that we agreed. I don't recall anybody agreeing with anything he said. The only thing we've agreed with him is to meet and try to talk this through. We're still willing to talk it through with him because, the house straight across from him is about 10 feet from the road, but it has a creek running
through it. Nobody made a peep when that variance sign was put up because there's an obvious hardship. There is none here. But if he moves that house 32 and we're standing on that porch across the street, it's going to look like that whole neighborhood is going to come down to this, because that will be another house very close to the road, directly across from the one that's already close to the road, and there is no reason for that property. There's no hardship. So the neighborhood just doesn't want that to happen. Appreciate it.
Thank you. And our time is up, unless there are questions. Very much appreciated. And we'll hear back from the applicant, who has some amount of time. 5 minutes and 15 seconds. Yeah, thank you. 5 minutes and 15 seconds for rebuttal.
If you look where the red dot on my house is and look 2 houses to the left, that's Oscar Miller's house. His house is set at 37 feet. If you look at his lot, his entire lot has been, all the trees have been removed, and he was allowed to excavate his entire lot. Critical lot plans do not allow for that. Critical lot plans that are new since these people built their house say you have to do minimal grading and minimal excavation. For me to put my house 60 foot back and to have a 15% slope driveway, I will have to remove 30 feet of dirt. I will have a 18 to 20 foot high retention wall behind my house, 5 foot behind my house, because I was given a clearing restriction. In excavating his lot, he took a lot just like mine with 32%, 33% slope, and he turned his lot into 16% slope in the technique that Lorenzo was describing, flipping the lot, where he took all of the height of the back of his lot and moved it forward and made it flat. I'm not allowed to do that. There could be not much more difference in a hardship than having a 100% steeper lot. A lot that's 16% and a lot that 32% there's 100% difference in slope. If I build my house in the back, I have 32 foot of slope from front to back of my house of earth that has to be removed and a retaining wall created to protect the house. By moving,
I guess, help me understand that, because, I mean, here's where, I mean, when I hear you talk and I hear the opposition talk, it just sounds like y'all are talking about 2 completely different pieces of property, and yet the opposition are your neighbors.
Yes.
So, you know, I don't see any other retaining walls on any of the properties from this aerial, and so why is yours?
The Millers have a retaining wall that they claim that cost them $100,000, that they're very proud of, that they had to create when they did their slope. And in doing, like I said, they cut off the back of their hill and moved their house forward and changed the entire grade of the entire lot. I'm not allowed to do that. I explained to Lorenzo when I met him, I showed him everything I was doing was to work with the slope of my lot and to create a situation where I could spread drainage away. He is correct that I have to do some excavation, but the excavation that I do for my house will then be used to backfill around the foundation of my house, and it will create slope in all directions away from my house so I don't ever have to worry about flooding. I have also had to add, and I have a different plan that I would have to get approved if my variance is granted, where I have a retaining wall, and that wall is 14 feet high at its highest point. And by going in the curve, I gave myself some yard instead of having a retaining wall that would be 10 feet behind my house that would be taller than my house. I don't want that to collapse and crush my house. I think that creates the hardship that I'm asking for. Oscar's house is at 37, and when you come to 2 more houses, that house is at 40. There are houses that have been granted this variance for the same reason, the hardship of their lot. Because they didn't have a critical lot, they were allowed to excavate their entire lot. In excavating their entire lot, they've created drainage issues, and there's erosion control problems in that subdivision. And some of those things is what created these critical lot plans so that you can't go in and totally excavate a lot, take out all the trees and create the erosion problems. I have made the best use of the slope of my lot and making a house fit. When he said, they keep saying I've never presented a plan. I do not have to have, if a house is under 5,000 square feet, you do not have to turn in building plans to the city. You turn in a plot plan. I have a self-drawn plan of my house that I have presented to them 3 times. One time when it was too small, one time when I put a bonus room above the garage to meet the square footage, and in the meeting I had with him this last weekend, I showed him that the new house has the basement garage that allows for the small slope on my driveway, and I would like to use my driveway every day, no matter if it snows or rain or ice. I would like to park in my garage. I think having a driveway that's at 30% slope hurts resale value if you ever want to try to sell your house and the person sees that he can't use the driveway. I believe those are the hardships that make it necessary for me to move forward. I understand that they still are not happy that I've turned my house on an angle, and I presented in the last meeting a Google Earth view of the entire neighborhood, and there are 5 houses in the neighborhood that are turned on an angle. So that is no different either. I have nothing personally against anybody. I've met with them many times. I continue to meet with them. As soon as I was told I had a new council person, I tried to work it out. You told me to redesign the house to make better use of the slope of my lot. I have redesigned the house and created, and to say that the house hasn't changed, the footprint of the house did not change, but I added a basement to my house. That's a pretty big change. And in adding that basement, that allows me to meet their side garage rules, and it also allows me to have...
Point of personal privilege.
Okay.
Time has expired.
Okay. Any other questions for the applicant?
I have a question. Do you have anything from Metro? They reviewed your critical lot plan. Is there anything that says this is the best place for this house on this site?
When I got my original permit from them and I came in to tell them I was applying for the variance, there was the person that I had to go through the paperwork stage that said that 90% of the time that this is granted, they grant it for this exact reason. They do not want you to build your house in the steepest part of your lot. If you have a lot that gradually slopes and gets to a flatter spot, and you can do the least amount of grading possible, that's where they want you to put your house, and they said that asking for the variance was my best chance of meeting those requirements.
Do you have any sections through the site where, because it's really hard to understand I'm looking at the survey and I'm looking at the spaces between the contour lines, and it's really hard to read on the street.
When you look at the lines, the farther apart a line is, the flatter your slope is.
That I know.
Okay. So as you can see,
that part I know.
Okay.
I can't read the image. The image quality is poor.
What I have done is I have the road is at 590 feet, and I have created a driveway where I enter my garage at 598 feet. So there's only 8 foot of gain to go in my garage. When my house is back 60 feet, I have a driveway that goes up 30 feet in height. When you go from 590, I go to 628.
I think a section, a drawing through the site would have been helpful.
If it would be asked to defer to this for me to provide some drawings that would show, what I'm trying to do and what would be necessary to cut out the lot, I would be willing to make those drawings and present them.
Any other questions? All right, we'll close the public hearing. Thoughts?
Laws change, and he just got caught, basically.
He's got a really steep lot, and I get that, but I'm with you, Mr. Chairman. I can't sort out. I mean, he's saying that's the hardship and it's unique, and the neighbors are saying there's lots of steep slopes, and then there's really nothing that's been submitted that allows me to. So I think that has to go against the appellant. I mean, I understand he has a steep lot. I also think that one of the neighbors hit on something, which is, and I've stated this position before, I think when if you are going in to build and you're requesting a variance, I mean, there's kind of that whole self-imposed hardship thing comes up for me when you are buying to build, and I think that
Make a motion.
that's relevant here.
I'm going to make a motion, we deny.
I'll second it.
There's a motion on the floor. There's a second. Is there any discussion? All in favor of the motion, say aye. Any opposed? That motion passes. Now we are on to page 3.
Next case for the board to consider is case 2019-393 involving property at 4422 Scenic Drive. This is a request for a variance from front setback requirements in order to construct 2 single-family homes. Before you is the zoning map showing you the zoning of the property is R20.
Is the applicant here?
Is the applicant here in this case? Yes. Come forward.
Yeah.
You can come forward, sit at the front table. This is the aerial photography showing you this property and the surrounding area. Site plan submitted by the applicant, and finally the photograph showing you the current conditions of the property as well as up and down the street. There is opposition present, I believe, for case 393. So each side will have 10 minutes. Please be sure to identify yourself by name and address before speaking to the board.
Hello, board. My name is Josh Melnowski, 2017 Galbraith, Nashville, Tennessee. I'm here today to appeal the 90-foot setback. Originally, I'd taken had a survey done on the property, and when I found that I'd taken that to an architect, and he had mentioned, well, you have the only triangle-shaped lot in the area. If you go up and down the street, they're all rectangle-shaped lots, very narrow face. It's a 275-foot width lot, where the other lots are, 80 to 150 feet wide. I'm asking the variance from the 90 to, originally this was a 40-foot setback, to keep the continuity of the original building plot of the house. I have met with the neighbors. I'm building this house for myself. There
are 2 houses, though. Right?
Correct.
Houses.
By 2 homes, yeah.
So you're not going to live in both of them?
I'm going to live in one, sell one to offset the exorbitant cost of the lot purchase. So building 2 houses, selling 1 home to offset the cost of the other property. And that's, and I've met with the neighbors, talked to the councilman, and then the opposition was runoff. I had the 2 oppositions, and I actually met them. It was the last hearing, actually, the first time I heard of an opposition was runoff. And we had spoken about that we're not going to, increase runoff, is going to maintain existing runoff or less, per codes. The second opposition was the site of the home. That was, and I met neighbors were great. The reason I'm looking to buy the property is you can see the tree line. It's a very, very, very private. It's a very private lot, so it's a very steep lot up to the hill. And so I'm looking to, we're looking to maintain the privacy of the sites of the homes, and that was why we asked. The variance actually came from the architect. He said, well, we could have left and went ahead and build as is, put the 2 homes on the property. It wasn't a variance to build 2 homes within the codes and governs of Metro. However, it was actually on the recommendation of the architect I was working with to go, hey, you have an irregular shaped lot, you've got a hardship lot, it would make sense to at least build in the original footprint of the home than tearing the home down and starting from behind the house. And so that would actually, you got neighbors behind, you got one on the right. It keeps the distance from them and trying to keep with the original, the building site.
What is that a hardship to build 2 homes?
No. A hardship is for the setback.
No,
Yeah.
I understand,
Yeah.
but when somebody's saying to you, have a triangle-shaped lot,
Yeah.
I see that, but I don't see that it creates a hardship for one home.
Well, you're going to put the home all the way back on the back of the property. It's not going to be where, the 90-foot setback is not where the home is. It's going to be directly behind it.
Because that home's at 56.
I mean, I see, this lot is absolutely different from the neighbors. It's not as deep, and I understand that. And I do see a hardship for somewhere between, 56 and, and 90. And, I do think 90 would be very difficult since the existing house has at least one point at 56 feet. Most of the house is further back on the edge. But it seems like that the request, for, the second home to go to 40 feet is only because of the second home. It's because of the shape of the lot and, forcing a second home there. So I guess I'm trying to understand, what is the hardship for wanting 40 feet?
Building, just the setback to build.
To build a second home,
the second home was added by Metro. The first time they had a setback, they said we were building a sidewalk variance. And so I don't know if there's a miscommunication there, but the setback we were requesting was just a setback closer to the further part of the property. There wasn't a build. We can build two houses at 90 feet.
Right.
And so we wanted a setback because the house on the left, the one on the right's not going to be necessarily encumbered by the 90-foot. The one on the left is going to push it quite a bit further back. So you're going to have more driveway up to the house. So you're going to eliminate a lot more green space. So it'd be nice to, have a playground, a park, or a little bit more green space up there. And also, instead of going up and tearing up land that you didn't have to tear up, you're building more in that footprint on the home on the left. And so that was really, that was it.
Can we see the aerial view again?
And have you spoken to your councilman? Because there is a letter, he does not support your application.
I did, and I had a conversation that I thought he did support it at the 56. And he was supposed to come here today. It was the last that I heard. He actually talked to the real estate agent. I talked to him on the phone. And he mentioned talking to the neighbors, and I had reached out and talked to the neighbors.
We received an email from the council member today that maybe before y'all, should be before y'all, that states that after neighborhood meeting, he was going to stand with his original opposition based on the neighbors' concerns.
Okay.
What's the footprint of each house?
Footprint, square footage, 4,200 square feet.
So what the specific request, what is your specific request for what? It's a setback to 56, or is it, you're asking, I think, for?
It was 40 feet, and then originally I had a phone call saying there's a recommendation to go 56 feet, and would go ahead and, if there's no opposition, agree. And so I said, well, we can go 56, because originally when I had the survey in the feet, I didn't see, the 40 foot I was trying to push where you can see that left driveway, the left side of that left corner, about 10 feet from there. And so I realized that corner of the house is 56 right there. And so, 56, correct, yeah, if you come with the Billmore, you see the corner lot. So we're like, well, 56 you can see the corner of the house where it is right now is 56 feet.
Right, and then.
And we said, we would agree to the 56 feet.
Well, and that was, again, based on an odd-shaped lot and being back at least as far as the existing house. But that also, again, was dependent upon neighbor and council support, which, we have I guess, 40 some odd signatures and lots of letters. I mean, there are a lot of folks that don't like what you're doing, and I have I'm trying to find, well, yeah, the petition just it talks about, you know, they opposed a setback, and so they're not, I don't think it really talks about specifically why they signed, you know, they signed it. They just were opposed to granting, you know, a shorter setback.
And that's where I'm confused. Of why, I mean, specifically the opposition of what's the difference between the 56 feet and the 90 feet?
No, well, I don't.
And that's what I try to bring, like, and all I got was, well, I don't want to be able to see your house.
Well, they may have.
And that's what I'm trying to get, like, and I got as far as like runoff. And the problem is, and the big thing is there's a development up the street, a condo development that has incurred a great deal of runoff. And that was their concern, and they've been trying to remedy this situation several times. And it's up on the hill, but it's a large condo complex. And then the neighbors across the street, and that was been their concern, was a runoff associated from gutters. And if you can see the development, you can see where the runoff, but there hasn't been runoff on this specific property.
It's not our job to ascertain necessarily what their underlying opposition is. So I don't want to go down that road.
Well, maybe we could hear from them.
Yeah, no, they'll say. No, I mean, it just, the applicant had just raised the issue of why people were opposed, and there's just a lot of people on record opposed, and you're right, we'll let them speak for themselves on that, and it's hard.
I think that'll clear things up.
Yeah. Did you have anything to add right now?
No, that's it. Thank you.
All right, you have 4 minutes and 17 seconds for rebuttal, and we'll hear from the opposition. All right, yeah, if you would, just state your name and address and tell us your thoughts, what you have to say.
Okay. Hi, I'm Lynn King. I live at 102 Braxton Hill Court. And firstly, we want to say we're not against development of the property by any means at all. We want to maintain the characteristic of our neighborhood, which has nice setbacks. In August, we took the time to educate the neighbors on the proposed setback variance and obtained 37 signatures. And you have an exhibit that has the places that we went, and who signed, who didn't care, and who cared, and who said no. We also consulted our councilman and also met with Mr. Malinowski twice. And, you know, we've had a nice working relationship there. Our main concern is that the variance will allow 2 homes to be built very close to the road to allow for a nice backyard for the owner, but then change the look and character of our neighborhood. The property has unique characteristics. It is in a flood overlay. It's on a hill above the floodplain, and there's a bit of a rocky cliff on the front of the property. So we don't really believe there's a hardship on this, that the hardship is self-imposed by really wanting to build 2 homes on a lot that just cannot take it. And we don't, it allows options, and we don't know what those options would be, much like the case you heard earlier today. We don't know what's actually going to be built. We have concerns about injury to neighboring property because building atop of, again, atop a hill on a floodplain, removing trees, adding impervious surface will increase potential for neighborhood flooding. And this is right on Browns Creek. So Mr. Malinowski has stated that he can't afford the property if he can't build 2 homes. We see that as a self-imposed hardship. And we just request that this variance be denied because of the issues mentioned and all of the neighbors that we educated about it. And I will say, it was really interesting as we walked around and met our neighbors. There were these two very friendly chickens that we didn't know were in our neighborhood, and we got to talk to the chickens. So I actually got to pick the chicken up. That was an adventure.
Did they? I didn't see the chicken's
Yeah.
footprint on your.
It's just a random thing.
All right. Well, I'll ask a question on the original. It looks like the original house. If you're looking at the picture here, and I'm looking at a site plan that superimposes that, from the corner that is closest to Scenic Drive is 56.5 feet, and so 90 feet because of this strange shaped lot compared to the neighbors. 90 feet is from that corner. It's a pretty difficult. I mean, if you were as neighbors were to say, we're perfectly happy with the owner, whoever it is, building a home exactly on the footprint of the home that's there. It might be bigger and newer. That suggests, some kind. I mean, and of course, the house is angled a little differently than how he's proposing it. But I guess what would an acceptable setback be? Is it? I mean, I know 90 is what the code requires, and you may come here saying, no, it needs to be 90. But as I look at this, I think, well, boy, 90 wouldn't even allow them to build on the existing footprint.
Could I address that?
Yes, ma'am.
I'm Christina Hansen. I'm at 4420 Scenic Drive. And so.
So you're next door?
Yeah, I'm the one that visually will be the most impacted. And I've, in the packet, you can see where sort of 40 falls. And there's also an aerial shot that shows you where 90 would be. So the current house is, because it's angled on the triangle, it's over 120 feet, going perpendicular coming out of the front door. And so that's visually, then I'm 200 feet back. All the other homes, the next 4 homes are 200 feet back. So to my mind, going to 90 is a huge variance from the required plat, which is 127. And I guess they set it at that angle at 127. So he wants to tip them so that they're perpendicular to scenic. So I understand, legally he can go to 90, but you have to understand that 90 is halfway down my yard already. So
which is where that house is now.
Yeah, right. The average of it right now is 90 probably, because the front door is 90. The side on the left is probably 50-something, and then the side that's near me is closer to 120, because it's tipped.
All right.
So 90 is going to put it a whole lot more in my front yard than the current house is anyway, so I would not want to do anything beyond 90. And he submitted plans to planning that with 90 setback, and I think you probably have those, he could build one house that was 4,000 square feet, and the other house was over 6,000 square feet. So with a 90-foot setback. And so the issue really is that he would rather have more backyard than front yard. And I would question, it's zoned R20, and there's nothing about R20 that guarantees that you should be able to build 2 homes anyway. All of the homes on the other side of the street are in the floodplain for Browns Creek, and they're R20. And, they're not allowed to build 2 big homes. So, I mean, he could have $1.5 million home very easily up there that would be, no problem at all. But without having a variance on the setback, he doesn't have as many choices. But I'm not sure that that's a hardship.
Okay.
Because he still can build 2.
Right.
So. Okay, so what else do I want to tell you? So I don't want my house ending up looking like a shadow house. I think that we have setback variances. We have setback requirements to keep conformity. And so all over Nashville, I mean, sometimes it's 80, sometimes it's 120, sometimes it's 200, but it creates that uniformity. And so that's that's all, I'm desiring, is that, it's enough of an ask to make me have to agree to 90 instead of what the plat was of 127. Because somebody wants to build 2 homes, and 2 homes of the way they want it to be designed. And then I would also question whether or not when some things cross from a floodplain, that you really want to increase the footprint at all in the land. The existing house is probably something like 2,400 square feet or something like that. And the plats, the footprints that I've seen from him, are 4,000 and 6,000, or possibly, if he gets the variance, he might do 2 that are 6. And so I'm not sure. He's told me he'll work with a good architect. He's told me he'll leave the trees. But there's nothing that really requires that.
Anything else you all would like to
You want
add?
to read Kathleen's? Oh, we have one more statement from somebody who didn't make it yet.
I won't repeat. This is from the neighbor Kathleen Irvin at 4415 Scenic. I told you about the 37 neighbors. There's concern here around the variance would set into motion a dangerous precedent, a precedent that would forever change the character of our neighborhood. We've heard about that in the earlier case today. It will prevent additional and unnecessary development of a parcel of land that is and surrounded by the floodway from Browns Creek. Again, we're not against the development of the land. We've met with the developer as well as our councilman. We understand we can't prevent the building of 2 4,200 square feet homes, but the buyer's assertion that his property presents him with a hardship because he can't have a bigger yard or have 2 driveways is an affront to the neighborhood. Flooding is a hardship. The erosion of our neighborhood's character is a hardship. The variance is unnecessary and unwanted by our neighborhood. Please honor the setback requirements. Thank you for your time.
Thank you. Any questions? Anything else to add?
No. You've got lots of paraphernalia to
Yeah.
look at. Sorry.
Lots of souvenirs.
And so we'll hear back again from the applicant, who I think has maybe 4 minutes and 17 seconds.
Thank you.
Thank you.
Hello again. Well, I mean, the hardship wasn't to build 2 homes. The hardship was a setback. And if you go down on Biltmore on the left down there, every home's sitting on 50 feet on a half-acre lot. This is like a 1.2 acre lot, 0.6. So it's double a home apiece. Again, I mean, this was brought up from the architect that thought, hey, you have this is a legitimate hardship. Who knows far more about the design and the area and land and building than I do. And that's what I'm saying. Like, as most of you guys are well more versed in the property than myself. So mine was, he was like, well, okay, if you build it up here, and his question was like, why wouldn't you build it in the original footprint of the house? If you're gonna build these homes, why would you tear this house and go further back? And so, that was it. It's for design, to have a tasteful design, to actually consider about the layout. Because it was real easy. We could have avoided this whole scenario, and we could have torn ground 3 months ago and built 2 houses without concern of how the properties will lay out. Actually, me coming forward is showing that I'm giving more concern. We could have very well built the 90-foot, built the 2 houses. We could have 5,000, 6-foot gone up, whatever, and within codes and everything. But we kind of had a chance to go ahead and request the setback because, we want to build a tasteful design, have it laid out. If we're going to build a house, and these are substantial homes, we want them to lay out great on the lot and work well within the landscape, and also try to maintain some greenscape. Now, the greenscape is on top of the hill. It's not, there's a hardship because most of this lot is a mountaintop, and then you go in the back and you have green space. So yeah, you could very well put the homes in the back and have just a bigger front yard. It's private. Either way would work. But again, it was kind of, I'm defaulting back, I'm not going to say, but the architect had brought it up. It says, okay, the board is made up of a lot of professionals. Talked to Metro, I'd gone to Metro 4 or 5 times down there. Everyone was great in zoning, and talked to them and just said, hey, this is a triangle. It's a regular shaped lot. No other lots like that. And one thing, as far as a precedent, it's the only triangle lot on the street. So if you're going to set a precedent, there's no other lots that are triangle shaped. And that's why that's an actual hardship. You can't have a hardship. They just don't say, hey, I want to set a zoning setback. I had to go through, a lot of meetings just to even approach or even put an appeal to you guys. It wasn't just an erroneous hardship. It's not a financial thing. That's all.
Any questions? All right, thank you.
Thanks.
We'll close the public hearing. Thoughts?
You've got an awful lot of neighborhood opposition. You've got the council members' opposition. You've got an imposed hardship that he created. I don't see that there's a basis to approve this personally, so I'm going to make a motion if, at the appropriate time, Mr. Chairman, that we don't.
I don't know that there's an inappropriate. I think anybody can make a motion anytime, and so that's fine. I mean, unless you wanted to hear from other folks. Christine, did you have something to say? Or?
No, I'll wait to hear the motion.
Oh. I think I heard the motion. I think you did. I mean, maybe inarticulately spoken, but. Make a motion that we deny granting the requested variance as presented.
I'll second.
Have a motion, have a second. Is there discussion on the motion? Then all in favor of the motion, say aye. Raise your hand. Any opposed? That motion passes. We will get ready for the next case if the applicant wants to come forward, but in the meantime, we will take a 5-minute break.
Before you shows the zoning of the property is RS5.
And this is just sidewalk, right?
Correct, just sidewalks. The aerial photography showing you the property and the surrounding area. This is the site plan submitted by the applicant, and finally the photograph showing you the current conditions of the property as well as up and down the street. Is there anyone here in opposition to case 396? Seeing none, the applicant will have 5 minutes to make your desired presentation. Please be sure to identify yourself by name and address.
Hello, I'm Buck Snyder. I live at 2219 White Avenue. I submitted this application requesting to not have to tear out the existing sidewalks and build to the new standard. In other words, to leave the sidewalks as they are now. The only exception is the curb cut, which is present in front of the property, would have been removed and replaced with the existing standard sidewalks. I've gotten a letter of support from Metro Historic, and I've talked to both neighbors on either side. So they're in support. The only other issue that came up was earlier today I received planning's recommendation, and planning recommended to leave the sidewalks as is, but to also pay the in lieu fee. And the only reason I'm speaking is because I don't understand the need for paying the in lieu fee.
Okay. Well, and your council member has also sent an email saying that he strongly supports payment into the fund, as most council members do. And basically, as we told a lot of people who come here for sidewalks, you can rationalize not paying into the fund on almost any piece of property. This one has a sidewalk that's perfectly good. Why should I pay into the fund? Other people will come with a ditch in their front yard and say, there's no sidewalk for 3 miles. Why should I pay into the fund? And both are reasonable, but when the city council passed the ordinance unanimously, it wasn't this board, it was the city council that passed the ordinance. It requires payment into the fund unless you build to the new standard. And in this case, Historic has said they'd prefer the rhythm of the sidewalk be maintained. And so they were fine with keeping the sidewalk, and planning was in agreement to say, well, the sidewalk can stay. But as part of the sidewalk law, if the sidewalk stays, you still can pay into the, required to, unless there's some unique hardship to the property that this board would find compelling to say, well, no, you don't have to pay, or you shouldn't pay as much, or that type of thing. So I don't know if that helps, but that's kind of what the rule is.
Okay. Then I'll probably just build the sidewalks to the new standard. It's going to look weird.
Yeah, well,
It's
it will.
going to be 28 feet out of like a 1,000-foot block.
Yeah. Well, and that, so I guess that is what, and I guess the question is, what's the difference in cost from your perspective in paying into the fund and building the new sidewalks?
The in lieu of fee is $5,000 about.
How, you're,
based on the email I got today from, it was $152 a linear foot. Yeah. Maybe I did bad math, but I thought it was about $5,000.
At 152 at 28,
4,200.
4,300.
and then what would a new sidewalk cost?
Well, we already have to replace a majority of it because the curb cut is coming out. It's a 16-foot curb cut, so. And there's another few broken tiles. So we'll be spending money pouring the sidewalks anyways. It's really just a matter of how they're poured back. So we can pour them back the way they are and pay $4,000, or pour them back to the new standard and not pay the fee.
So would you be willing to replace the entire sidewalk as where it is if you're already doing that much pavement?
Yeah.
So that would be an option for us to consider.
To let them replace.
Replace the entire sidewalk. They'd look good, but then you'd have brand-new sidewalks that is more in line with what Historic wants, but they would be brand-new sidewalks. Something to consider.
I would consider that.
And I assume that would be cheaper than the in lieu fine.
The sidewalks would be less historic, though.
Yeah, well, that's true. I'm sure they'll get a patina. Yeah, I'm sure they're younger than the home. Maybe they are or not. But again, part of our job is to try to figure out, how to maneuver in these areas like your home, which has a different message from Historic that from the council regulation, which would be build it up to the new code, and also match that with the requirement to pay in a case where it may or may not make sense. But if, as you said, if you are already doing a substantive amount of repouring anyway, then it might make that might be an option. Is that, and I don't know how everybody else feels about it, so that's why I can't offer it to you, because I'm just trying to get a sense of it for everybody else. So if we did have a motion, we talk about it. So, did you have anything else to add?
The only other thing I'd mention is the Metro standard for the sidewalk that we'd be required to build to does have an exclusion for historic districts.
Right.
So maybe that would affect the decision as well.
Okay. Any other thoughts or questions? Anything else you'd have to add?
No.
Okay, we'll close the public hearing.
I'm fine with your proposal. Can we also approve it based on planning's recommendations? That way he can basically select.
Okay, so if I hear you right, then we will approve the variance with, and allow the applicant two options. One is to bring the curb cut up to code, which he's already stated he's going to do, and replace the existing sidewalk as in the exact same location with a new sidewalk, or the applicant may pay the in lieu fee. Is that?
Yeah, I mean, I'm fine with either, so
And so that
it
it's up,
sounds like he's made up his mind.
well, it's up to the applicant, and I think that the first option, well, again, it's not for me to choose. First option, I think it's been stated, is probably going to be a lot less expensive than paying the fee or putting in the new sidewalk. But those would be the two options, that replace the current sidewalk or pay the in lieu fee. So that's a motion. Is that?
I have a question. So when he replaces it, is he replacing it to be consistent with what's already there, or is he replacing it to?
No, replacing it as in the exact same spot per the Metro Historic recommendation.
Yeah, I support that.
So it would just be a brand-new sidewalk in the historic spot, which conceivably would give it a longer life and satisfy, hopefully, the folks that want you to pay or do something. And it seems like the compromise. So that was my motion. I don't know if there's, I've got a second. I have a motion, I have a second. Any other comments? All in favor, say aye. Anybody opposed? Thanks.
Thank you.
Next case.
2019-398 involving property at 1704A 17th Avenue North. This is another sidewalk variance request to construct a single-family residence without building sidewalks or paying into the sidewalk fund. Zoning map before you shows the zoning of the property is RS5. Aerial photography showing you the property and the surrounding area. Site plan submitted by the applicant, and finally the photograph showing you the current conditions of the property from a recent site visit. Is there anyone here in opposition to case 398? Seeing none, the applicant will have 5 minutes to make the desired presentation. Please be sure to identify yourself by name and address.
Hi, my name is Sean Roberge. My address is 925 North 5th Street.
Eddie Latimer, 1610 Sumner Avenue.
I am the builder for Affordable Housing Resources. The property in question, 1704 17th Avenue North, is an award from the Barnes Fund, the mayor's initiative to create affordable housing in Nashville, Davidson County. This year, we have had 4 properties in the last 6 months in this same neighborhood, 811 Lena Street, 1540 12th Avenue North, 1620 12th Avenue North, 1524B 23rd Avenue North, which all came with a staff recommendation for approval for a variance in the sidewalk, because it's been the city's initiative and the mayor's office initiative to promote affordable housing within the city because of the shortage. Now, when we applied for this, staff's recommendation said, let's pay the in lieu fee of. That in lieu fee is $7,600 for this property, which is a cost burden to the people we're trying to help.
Do we know anything about why planning?
Yes. Short version is because Public Chapter 685, House Bill 1143 from the fine folks at the state of Tennessee's legislature passed legislation that said, thou shalt not be kind to poor people who need affordable housing. I'm paraphrasing broadly there. However, if you read the specific language of the bill under Section 1, Section 1B, it reads, conditions any zoning change, variance, building permit, development entitlements through amendment to the zoning map or any change in land use restrictions or requirements on the allocation of existing or newly constructed private residential or commercial rental units to be sold or rented at below market rates. Sorry for the kind of technical reading of it. I won't have it in the record. We can't give zoning entitlements in exchange for affordable housing, capital A, capital H, not just the slightly less expensive housing, but our actual defined affordable housing. If there is literally any other legitimate basis by which the board can grant relief, then the board can grant such relief. However, It's our understanding, having worked through this more, not just on sidewalk questions, but also on floor area ratio bonuses and other similar items existing under the Metro Zoning Code, that this law prevents utilization of those fairly convenient tools previously in our toolbox in conjunction with affordable housing bonuses. So if you have any other basis whatsoever by which the board can hang their hat on a hardship determination, then that would still be fine to grant the variance. However, in the past, we have sought what we thought was a correct but also rational recommendation for the consent agenda, particularly with Barnes Fund cases. Nobody thinks that it's logical to say, here's a big stack of money to go build affordable housing, now give us the money back for a sidewalk fund contribution. But that's why we are where we are. Sorry for kind of a long answer, but I thought the detail of the law was pertinent.
So the mature tree that prohibits construction of the sidewalk may be, all right. All right, was there anything else that you wanted to add? I mean, I think I understand the situation and why we're here now instead of you already being at home planning to finish this project. I'm sorry.
May I follow up on Mr. Michael's explanation? And he is exactly correct.
Yes, please.
As to how these things have been evaluated based on the state law. But I also want to share with the board some thoughts about how you look at sidewalk funds. When you look at the provisions in the code, your challenge or your task is to look at whether or not they meet a variance standard. Whether or not, that's one question. There's a separate question as to whether or not they pay into the fund. The standard for whether or not you pay into the fund is not a variance standard. In other words, paying into the fund is a condition of having gotten the variance. It's not required that you pay into the fund. The code section 1720-125 says right to appeal and seek variances. It says the Board of Zoning Appeals may require a contribution to the pedestrian network consistent with the subsections of 1720-120D, and those are the sections that you have authority to vary. An alternative sidewalk design, that's another option for you, or other mitigation for loss of public improvement as a condition of the variance. So I want to share that thought with the board as you look at this, to approach it from the standpoint of these are additional conditions that you can impose, one of which is paying into the sidewalk fund, but there are two others.
If we provide a variance, it's generally, I don't know if it's required, but we usually state the hardship or the reason.
Mm-hmm.
On the next question of payment, is that necessary?
No, you don't have to have a hardship for.
So I don't have to, if I say, based on
because
whatever criteria I have here,
mm-hmm.
I choose to vote on a variance, then I don't have to give a criteria or any reason of whether or not they pay.
Well, there should be some basis for either, I guess I'm challenging you to think about it from the standpoint of that's not your starting point. That's what you add onto your decision as a condition because that's what the law says. Not starting at you pay into the fund and you have to give me a reason why you shouldn't. So it's kind of a different way of thinking about.
But one reason I can't give is specifically affordable housing.
That would be correct.
All right.
If I may, we would be willing to sign a form designating a right-of-way for future sidewalk improvements for the 4-foot grass strip and the 5-foot sidewalk.
And that's what we've done sometimes is in lieu of payment. Okay.
And
all right.
that
Thank
is
you.
Other mitigation.
You don't have anything else to add? I don't know if I formally closed the public hearing, but
it's a question for the
Yeah, ask the question and then we'll close the public hearing.
The tree that has a green tag on it, and it's close, it appears that you've excavated a little bit over towards the stake. Is it going to remain?
Yes, sir.
What type of tree is
We've
it?
pruned the tree down in order to accommodate.
That's not an NES, whatever they used to call
We
those
actually
cuts?
did to accommodate overhead lines, so we had to prune it down a little bit.
Yeah. What type of tree is it?
And it's a maple.
Okay.
It's a maple.
Okay.
Any other questions? All right, we'll close the public hearing. Since our rules have changed in a way that is new to me, and based on everything I've heard and the recommendations of the Planning Commission, I will, and I'd like to move that we approve a variance, and that in lieu of paying the in lieu fee, that the applicant, because of the mature tree and the inability to build the sidewalk up to standards and the alternative sidewalk that is designed that is currently existing, is fine, that if they would agree to the right-of-way, that would compensate the city rather than the in lieu fee.
I will second.
Motion, a second. Is there any discussion?
So can you run that by me one more time?
That the variance is, I move that we approve the variance and that they dedicate the right-of-way and that they don't pay into the fund because they're, in this specific case, are dedicating the right-of-way.
Okay, all right.
Any other? Any, all in favor, say aye. Any opposed?
Just the second part of that, I'm paying into the fund.
So they're not paying 1-2. So 5-1 passes. All right. Great. Thank you.
Thank you.
Next case.
Next case for the board to consider is case 2019-403 involving property at 1025 9th Avenue South. This is an item A appeal challenging the issuance of a permit. Before you is a zoning map showing you the zoning of the parcel at issue to be RM20. Aerial photography showing you the parcel and the surrounding area. This is the site plan at issue on the permit that was granted. And finally, photographs showing you the current conditions of the property as well as up and down the street. There is opposition here, so each side will have 10 minutes to make their presentation. And please be sure to identify yourself by name and address before you.
I'm sorry, Emily.
I was going to, go ahead.
Were you going to?
Go ahead. I don't know.
I was just going to say, have John talk first. You're ahead of me. Thank you.
May I speak first? Actually, I need to recuse myself from this case.
Okay. So Ms. Karpanek will recuse herself before the applicant identifies himself by name and address and makes his presentation. The zoning administrator will address the board with his reasoning for allowing the issuance of this permit.
Mr. Taylor will be brief on this because this building permit was issued by staff after the determination that it in fact met the requirements for building permit issuance for this particular project, specifically having met the requirements for the community education use under the land use table. The definition under our definition section of the zoning code, 17.04060, reads, community education means instructions on an elementary, middle, and high school level approved under the regulations of the state. That's short, that's broad, and that's probably intentional based upon the original drafting of that definition. Community education is a use that's permitted with conditions under the zoning code, specifically identified at zoning code 17.16040A, as in Adam. And for us, the primary question is whether the building and its intended use, and that latter part matters here, meets under that very broad definition of community education. We determined that the building and its intended use is, in fact, consistent with community education. Obviously, there is a certain uniqueness that this is a private-public partnership, not just a plain old government building being built solely with government funds. However, although that's not lost on any of us, it's also not something that tips the scales the opposite way into determining that this is not an allowed use at this location. Our determination was that the intended use is an allowable use due to MNPS having access to and use of the proposed structure under the plan that's been put forth through the permit and by all the of the interested parties. I know that you'll hear from two very capable and experienced lawyers today to make their arguments for and against. I know that a number of other neighbors, neighborhood groups, institutions involved in the area will also be able to address the board, so I don't want to put any more of a thumb on the scale than that. We determined that it met the requirements and thus issued the permit.
And is there a property map? Do we have the site map? And so, go back to that one you were just showing, that one. And so, just for clarity, because I didn't understand this when I was first looking at it, that the property, the athletic facility, the building that's being proposed is going to take place in the red area on this map, which is owned by MNPS, and there is a lease that, and I don't know if lease is the right word, but anyway, there's an agreement between Belmont and Rose Park for fields, but the facility that we're talking about is on MNPS land, not on park land.
That's correct. And as I know, I'm sure the lawyers will work through the particulars of that, but MNPS controls the property that's in question for this case. It is on the school property. Obviously, if you know the area and you've driven through there, you know it just kind of looks like one big uniformly functioning space, but there is the parks lot and there is the school's lot. This is the school's lot that's in question, and the school board has taken up their consideration previously, so whether or not to allow the use of this facility and construction of the project at this location.
Right, and I know both attorneys mentioned that, but just for clarity to the board, because it wasn't, when I first read all the materials and I didn't see the property map, it was a little confusing. Thank you.
John Michael, can I address that issue before we start? Just because that'll answer your question you just posed.
All right.
That point is somewhat, Adam Lefevre, business address 513 3rd Avenue South. That issue is somewhat moot now. Belmont has filed a bill with Metro Council seeking to ratify somewhat the lease between MNPS. I think there was recognition that MNPS by itself didn't have the authority to sign off on a lease like that it had to go through the legislative process, through council, and ultimately get signed by the mayor. So that is issue number 2 in my brief that's now moot because Belmont is, again, going through council to try to get approval of the land use there.
That is separate from what we have to deal with today, I hope, right?
Well, that's separate because one of my arguments in that brief was about the fact that that land was improperly granted. Belmont is trying to remedy that by going through council now. So that issue you were talking about of whether or not it was a lease, whether or not it was an easement, that is separate now because it's going through council.
Does it not have to go through council regardless? I thought that leases for MNPS, that I thought they had to, that MNPS could grant a lease, but then council had to approve that. So how is that like going, how's that skirting the process? It sounds like it just is the process.
Well, that didn't happen. Construction started on this facility before that happened.
Okay.
So MNPS granted they called it an easement, I think, to be creative around calling it a lease.
And this board has never had a case where somebody started construction before they came
Of course. Of course. It's rare in that construction is started, construction started before it goes through council and gets council approval. But that issue that you were discussing is now moot.
Okay.
So I'll go ahead and start. Yeah, I'm Adam Lefevre here on behalf of Organized Neighbors of Edgefield. A little history, and I know it's in the packet I submitted, but the relationship between Rose Park and Belmont primarily started in 2007. There was a lease that Metro did approve in 2007 that allowed the construction of all the facilities, the baseball fields, softball fields, soccer fields, track. That process did go through the legislative process to obtain the rights for the lease, and it also came before this board to get a special exception because the zoning for the park didn't allow for a couple of the items, a stadium, concession stand, and all that ultimately went up to the Court of Appeals because it was so heavily disputed. But regardless, the facilities are built there now. Throughout the lease, many of the neighbors have had issues with whether or not Belmont's complied with it. I submitted a copy of the sign in your package that Belmont placed over the parking signs for the park that said Belmont faculty parking only. So many of the neighbors have questions of whether or not Belmont's complying with the lease. We have neighbors here on both sides of this issue. Again, this is an item A, so we're just determining whether or not the zoning administrator erred, not whether or not any of these people here really want it or are against it. So fast forward from 2007 with the lease to 2017, there's a proposal by Belmont to build this 20,000 square foot batting facility on Metro Park land. And that was opposed by the neighbors And it eventually ended up being opposed by several council people. One council person used the word deceived in the way the bill was written. It was written as a batting facility adjacent to the baseball field. People saw eventually the 20,000 square foot, 2-story facility and said, hold on. And several council people at that point said, we need to have discussions, community meetings, and then the issue just kind of went away for a while. Then I received a call in June of this year saying, what's going on? There's construction at Rose Park. Is this related to the batting facility? Find out that after abandoning the park project, the process was circumvented to the MNPS that we were talking about, where the easement was granted across Rose Park School. So construction started, we've now graded, we've poured footers. So the item A appeal has 2 main points and a third that I'll argue today. The first one is moot. Again, that's the one that's going through council now. Second one is that the RM20 base zoning for this property doesn't allow a 20,000 square foot, 2-story batting facility. RM20 is primarily residential, multifamily use, and this simply doesn't comply.
That school's on RM20 too, isn't it?
The school is on RM20. So you can get a special exception. I mean, school's been there for a while. I don't know the year, probably prior to some of these regulations being in place. But the facility does not comply with RM20. I think that's indisputed. I passed out the floor plans of the facility to you early. I think you have those in front of you. And the argument that Belmont makes is this is for the children. That's their basic argument. This is for the children. It's for public school students. And I think if you look at that floor plan, the first floor in particular is one big room with a couple mechanical rooms and a lobby and a bathroom. And that's it. The second floor has a girls' locker room, a boys' locker room, office, 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 balcony, bathroom, bathroom, and a small conference room. And so the argument Belmont makes is that this is for the community, and the community will be able to use this, so it's great for everybody. The MOU, Memorandum of Understanding, that's in your packet as well, gives Belmont exclusive scheduling authority over this facility. So in theory, there's no guarantee that anybody in the public could ever use this. A student, Rose Park, for example, doesn't even have a baseball field. No middle schools and MNPS do have baseball teams, or a baseball team rather. No schools have them. So who's going to use it? We're going to have to bring in students from other schools to use this facility when Belmont has practices there nearly every day. Belmont's baseball schedule for 2019, for example, they had games on February 15th, 16th, 17th, 19th, 21, 22nd, 23rd, 24th. So I think the pattern of the exclusive use of this overall property is pretty clear. So that's the argument of the property doesn't comply with RM20 zoning. Perhaps the most important argument, though, is that Belmont, in their response, for the first time, raised the community education exception. Again, claiming that this facility is for the benefit of the community. And while my client disagrees with that strongly, if the permit was granted based on the community education exception, it was still granted in error. If you can pull up the site plan. Community education is governed by 1716-040 educational uses. And it's specifically setback, where elementary and middle school structures and outdoor activity grounds abut a residential zoned district or district permitting residential use, there shall be a minimum setback of 50 feet. That's for elementary and middle school. It gets larger as you go to high school. But I think it's evident by that picture, I think we're at a 10-foot setback between the property line. And you can say, yes, it's a park. It is. It's still base zoned RM. Across the street is residential. Catty corner is residential. So all the surrounding areas have a base zoning that allows residential use. And a 50-foot setback would then apply. This structure, again, it doesn't have the exact measurements, but it appears to be 10 feet off the property line. So you have, if you look to the left of this building.
And that's the side setback, right?
That's the side setback, yes. And so if the permit was granted under base zoning, which it originally was before the argument of community education, if it was granted under base zoning, it doesn't work because the structure isn't permitted in RM20. If it was granted under community education, it doesn't work because it doesn't have a 50-foot setback. So neither of the applicable permit requests, either base zoning or community education can work with that facility. And so we would ask the board to grant the item A appeal. And if Belmont wants to follow the proper process and apply for a special exception or a setback variance, then that's up to Belmont. They, of course, have the right to do that just like they did in 2007.
But the school, you know, I don't know how far Rose Park Middle is from the road or from the park, but if they were to build another classroom, would they have to come back and ask for an additional special exception?
It depends. There's a provision that says if the structure has a CO, and it states a date, I think, prior to the effective date of this ordinance. If it has a CO, then it's somewhat exempt, but this isn't the existing structure. This is a completely new building.
Right, but the principal of the school has written a letter saying that the principal believes that this has educational benefit for the school and the students of the school. And MNPS, by their vote to lease it, also said the same thing. So, and just looking at those, and we have lots of other neighbors and interested parties, including, I think, the vice chair of the organization that you represent, or at least that's how they're, or the co-chair, you know, supporting this and saying that it has educational, you know, benefit. So I guess how would the school be, you know, if the school, as you said, may have the right to put it closer, how is this different than?
The school, I'm sorry to interrupt.
No,
so
I think
the school or Belmont certainly has the right to request a special exception and go back through this board to get a variance to allow the building to be where it is. But it's clearly not 50 feet off the property line as required under community education guidelines.
Maybe, but, okay. Is it better for you if Belmont has to come before us for a special exception?
It is. It is. My client feels like, and I'm going to be candid, my client feels like this process has been railroaded. We go through parks, there's objections, council objects, it goes away. All of a sudden it goes through consent agenda at MNPS where several of the school board members say, I had no idea that was on there. And so the community, at least a large portion of the community, feels like they've been railroaded here. And so they want the opportunity to step up and speak about this. And council will be able to do it at council with the land use issue, but they want to be able to object and not just have this project built while under an item A appeal, construction and footers are poured. And so this project is continuing ahead despite the opposition. So
I guess, I think you did summarize this a minute ago, but just, and you may have more to say, but I want to make sure I get this before we hear from the other side. Item A appeals state that the zoning administrator erred. So specifically, again, how did the zoning administrator err?
It's a double-edged sword. If you're looking at it under base zoning, which to my knowledge, when you go in and apply for permit, you don't have to say, I'm applying for this under base zoning or I'm applying for this under community education. But if the permit was issued under base zoning, it doesn't work because a 20,000 square foot batting facility isn't a single family or multifamily residential use. I think we can agree that.
But let's say I don't believe that because it's already a school and it does go under community education. That's the 50-foot setback.
So if it is community education, then the permit shouldn't have been granted because that structure doesn't comply with setback requirements.
Okay, they should have had a setback variance before they started.
Correct.
And ultimately, those are the two reasons that you have where the zoning administrator erred.
I mean, I could, yes, where the zoning administrator erred, I could go.
Because that's all we're looking at, right?
Correct. I could go into several other issues, but those aren't relevant to
yeah, and I get that, and that it's difficult in these cases to just focus on that, but that is all we're focused on today is how did the zoning administrator err, and when we say zoning administrator, it went through staff and ultimately we're not necessarily saying it was John's.
Right. And that's the tough part with an item A is I always feel
I know
like.
he's reviewed it and all that, but that's your case those 2 points.
That is, and I have a long line of people that would love to get up and speak, but again, under an item A, it's somewhat irrelevant what they say as it relates to this board's determination.
Okay.
So if I can, so your unstated comment is, instead of coming in asking permission, they just did it.
They just did it, and when they did it, they were aware of the opposition, and that's perhaps what frustrates my client most, is there was opposition to the parks project, enough, as I stated, to where council people were really concerned, and then it went away, and then it just came back with bulldozers before, and one could argue that public notice was given because it was on the MNPS school board, which that argument has been posed to me. Notice was provided, it was on the MNPS school board website. This is a land use matter. This isn't a school matter when you're looking at it from a community's perspective. That answer the question?
Absolutely.
Okay.
Thank you.
Any other questions right now? Anything you'd like to add right now?
I'll reserve the 3 minutes.
Okay. All right, we will hear from I'll say the other side because I never know in these cases who's opposition and who's, I'll hear from the folks who support the zoning administrator's decision. How's that? All right, if you would, state your name, address, and tell us why you're here.
My name is Doug Sloan. I live at 6354 Torrington Road, Nashville. This is my first time appearing on this side of any of these tables, well, in this part of the county, anyway. With me is David Proffitt from MNPS, Ronnie Greer, former council member and driving force that began all of this partnership at the park and at the schools. Dewana Wade. Dewana is with Salama. I wanted to make sure I got that right. And Brenda Morrow, who is the president of the MDHA Edge Hill Apartments Residents Association. And I'm going to first ask that the property owner speak and allow David Proffitt to speak.
For the record, David Proffitt, Executive Director, Planning, Facilities, Maintenance, and Construction for Metropolitan Nashville Public Schools. Mr. Chair, if I may, just a side note, it's not often said to you members sitting up there what you all go through. It hasn't been too long since I was actually sitting on that side, and I was a chairman of a board of zoning in another city several years ago. So I understand the tough decisions that you all have to make and go through every meeting that you go through. This, contrary to the person who just spoke, I was not aware of the parks issue prior to the decision to move forward with this. This was brought to me as a opportunity for our kids. I saw it as a win-win situation for our children, and that's what I'm charged to do, is to create and build win-win situations for our children. All of our high school softball, baseball, and golf programs will benefit from this building. And in that sense, it's an educational facility. It's an ancillary building to this particular building. And yes, it's a win-win for Belmont as well. They get to use a batting facility adjacent to a baseball field that they use. But because it is where it is, it also benefits us. And we have been assured that we will have the use of the facility when Belmont is not using it, and they can schedule it. We have talked about the opportunities for co-utilization. There's I believe three batting lanes, two golf cages, or maybe one golf cage. The point is that we have talked about those, and we have determined that we're going to have a good facility there for our kids. So we went forward with it, and our board knew about it. In fact, I spoke to the board, if I'm not mistaken, that evening when it was passed by the board. So it is a win-win situation for Metropolitan Nashville Public Schools. We could not have a facility like this in the means in which we're budgeted to afford a world-class facility like this that will benefit our children.
And who do you all anticipate, what students, who's going to benefit, and how do you see them benefiting?
It would be through a scheduling process, and the scheduling, the labor force, if you will, is being provided by Belmont.
But I mean, will it be coming from different parts of the city, or
Yes,
from
sir. It'll be coming from any high school that wishes to schedule it and use it for their teams, or softball team, or a golf team for that matter.
Does it concern you at all that Belmont will remain in total control of the scheduling?
No. I have enough faith with Dr. Fisher telling me face-to-face that we could use it. Yes, there's a legal agreement that says that they have the quote-unquote first rights, if you will, of that scheduling. They're also paying the bill for the building, so you expect a little bit of, lack of a better way of saying it, generosity of use of the facility. So no, it doesn't concern me. I'm very comfortable in moving forward with the project, or quite frankly, had I not been assured that we would have the opportunity to use the building to a level that I felt beneficial to the kids, we wouldn't have approved it.
If I can address that same question, I had another packet handed out today as we read the new letter from the appellant, and I have in there a copy of the lease agreement, and if I could get you to skip ahead to page 2 of that agreement and paragraph number 9, right at the bottom, it says, MNPS and Belmont shall work together to plan the use and programming of the improvements. It is not like it has been portrayed to you as just Belmont making that decision.
And I think it also says that either party can terminate the agreement with 1 year's notice, as long as, I think, if MMPS ended up with the funds or the donor to buy the facility, they would have to pay for part of the facility, but either party can terminate that agreement within a year. And
they could terminate for convenience the way that you've described, but if at any time Belmont doesn't live up to the obligations that are set out in this agreement, then they can terminate it without that.
Yeah, it's a two-point piece. One, if they don't live up to their commitment, the building becomes ours, they go away. If, however, we do it for convenience, then we have to appraise the building and buy it for fair market value.
so one of the things that, I guess, the question I'd like to get to, and then I know other people want to speak to, and I want to make sure there's certainly time for that, since my question doesn't count against your time. But would you address the two specific areas that the appellant mentioned that, because again, we're not here to debate whether this is a good thing or a bad thing for the community. That's not this board's task today. Did the zoning administrator err or not err? And the applicant has said that in two ways, if you view this as the base zoning RM20, then you wouldn't be allowed to do this, which makes, that makes sense, I think, because it's RM20. I don't think it's allowed in RM20 maybe, but if it's because it's a school, there's a 50-foot minimum setback. And so
yeah, I can address both of those
if you would address, because that was the core of his, so when I asked, how did the zoning administrator err?
I understand.
And then you tell me on either of those points or in additional points, how the zoning administrator did not err.
Okay, and I think maybe there's just some confusion because in Metro Code Law 1708030, it's the land use table, and I believe that it allows community education on RM20 zone property is permitted with conditions, and I believe that is correct. As far as
But so that would allow the school, and so then tell me about the setback.
Okay, and the setback, he
moves on to that. I thought his issue was with the structure itself, that it was two-story or something like that.
2 stories within 50 feet.
Okay,
well, that was if it was a community education. If it was allowed under the base zoning, is that structure allowed?
I believe it is.
Mr. Chairman, so as not to overstep, thank you for inviting this. When we talk about being permitted with conditions, that takes us to the different section of the code. 1716 identifies 5 and then some 5 specific conditions with some sub-language. The second one, which Mr. Lefevre identified, is setback, and the 50-foot setback is required for community ed use. That's one of the conditions. So how do we get around that? I'm going to open a different ball of wax, but I know that Mr. Lefevre is prepped on this, so he can address it on his rebuttal. We have worked with Metro Legal for years to make sure we understand the interplay between school board's authority to use its land, a very pertinent issue here, versus our zoning regulations, which in many instances bump up against what their proposed use of the land is in terms of the structures, setbacks, height restriction, or other bulk regulations. The opinions that we've received from the Metro Legal Department, speaking broadly here, point back in particular to a Court of Appeals case from 1982 out of Gibson County that talks about the very broad authority of school boards to be able to utilize their property without being constrained by municipal zoning ordinances. I'm phrasing that very broadly. There's also an Attorney General's opinion out of 1985 dealing with similar issues that confirms that general position that local school boards are not going to be constricted by municipal zoning guidelines. Here, we talk about community ed, and it might raise the question, well, what's the point of this section of the zoning code if community ed has these restrictions, but local school boards don't have to deal with that? We have to remind ourselves, of course, that not all community education is necessarily part of your local education, local education, LEA, local education authority, your local school board, many are private schools. And they would have to go by these guidelines. So again, without going too deep into the analysis that we've gone through with Metro Legal Department in the past, and I'm talking 5, 6, 7 years ago, probably the most recent times, looking at the Court of Appeals decisions, looking at the Attorney General opinions, and looking at the very broad statutory authority still in place under the TCA for local education authorities to utilize their property without the constraints of the zoning code, here differentiating from health code standards, building safety standards, and locally that would be codified at Chapter 10 of the Metro Code of Laws, Chapter 16 of the Metro Code of Laws, respectively. They still got to build a safe building. They've still got to make sure the water's clean or meet all the health standards. But as for setbacks, height restrictions, and other bulk regulations, the opinions that we've received and that we don't have any reason to disagree with are that they've got extremely broad authority to bypass those if need be. Presumably, that's precisely what they've deployed here as their strategy for the placement of the building that's in question.
And if I might add, Mr. Lefevre pointed out that the zoning code talks about 50 feet from an abutting residential property. But the zoning code, and I assume your legal counsel probably has zoning code in front of her, it actually defines abutting. And it specifically says that abutting doesn't include properties across a public right-of-way.
And I guess I'll just ask our Metro Legal representative if there's anything that she would like to add to what the zoning administrator said, not to put you on the spot, but.
Yeah, you did.
Well, but to say I have nothing to add is perfectly acceptable.
I actually have nothing to add. I, as you all know, I don't sit with this board every single time. And I was not aware of that legal opinion that the zoning administrator has relied upon until this meeting. So I've not researched it the way the attorneys that wrote that opinion have done. So I don't have any information that is contrary to that. I've always operated under the notion, and I believe there is a different section of the code that talks about Metro having to abide by its own rules. However, I've perused the legal opinion that has been shared today, and I have no reason to think anything contrary, given the fact that they have researched it and I have not. I'm happy to do that for the board if the board would like to refresh on the opinion that is, as Mr. Michael has stated, has been in effect for a number of years. But I have nothing to add as far as that's concerned at this point.
Chairman Taylor, if I may.
But I will also say Mr. Sloan is correct. I was checking everything that everybody has said in the zoning code as they speak, and I did check that definition, and that's correct.
Our Metro legal counsel did tell me several years ago about those two opinions that the zoning regulator just mentioned. I want to make it perfectly clear, when and where we can, we absolutely follow the guidelines. We don't take those variances, if you will, very lightly.
It is at your experience that when you do need to build in a situation like this, that you have done so without coming and asking for variances because you have the right under those cases?
That is, generally speaking, that is the correct assumption.
So, I mean, just to your knowledge,
But
that
it
has
happens
happened before.
it happens very, very infrequently.
Okay.
I'm not sure where we are, but we'll go back to you.
If I can introduce Dwana Wade again.
Good afternoon. I'm Dwana Wade with Salama Urban Ministries. We are located at 1205 8th Avenue South. We're an organization that has been operating in the neighborhood for the last 34 years and hope to do so going forward. We have all seen many changes that have taken place in the neighborhood. And all of that change, it often seems we think of our youth last, unless there's some crime or problem that we seek to attribute to them. We're proud of the work that we do at Salama, and we're grateful for other agencies and the schools in the neighborhood who also serve our youth. We're especially grateful for Belmont's support that has supported our Salama students in helping to increase their reading and literacy scores over the last 3 years, a direct result of a Belmont faculty member and her students that come and tutor our students every week. In all of the services that we provide, that other agencies provide, that the school provides, it's still not enough. We still don't have the capacity to serve all of the students in the neighborhood. I'm here to speak to what I believe is in the best interest of our neighborhood youth. That's that they be given even more opportunities to grow, thrive, and be embraced in their neighborhood. I've been honored to participate in collaborative meetings with school personnel, congregations, community members, and other nonprofits to pool our talents and our resources to plan for increased, no-cost, after-school programming and services for students who live in Edgehill and others who will come from other schools. This collaboration is an example of the community coming together to provide an opportunity for education and enrichment that doesn't exist anywhere else in the school system, and Edgehill will be the beginning of something that can and should be replicated in other parts of the city. This is more than a batting facility. This is public property that will be developed for public use that will benefit the children of our community through increased services. Thank you.
No questions for you. Hello, everybody. Thank you all for allowing us to come in. I'm Brenda Morrow. I'm the president of the MDHA Edgehill Resident Association. I'm also the director of the United Way Family Resource Center in Edgehill community. And we are here. We brought people from the community. Y'all stand briefly. We've got people from the Edgehill Community Garden. We have people from the Residents Association. We have people from the Organized Neighbors of Edgehill Board of Directors. We have a whole collaborative of people that actually come together and look at the needs in the community. I wanted to actually touch bases on the fact that we've had big community meetings around this batting facility, around the issues of what it will look like when it's finished. And I've had, well, actually, we had 2 meetings, 8/28, around the annual Rose Park usage and facility usage report. And we had over, I guess, about 17 people that attended that to find out of the money that's given to the community, how it's been used, and how the residents input it. One of the things we've always tried to make sure that ES Rose Community Center has what it needs. The residents decided that they needed to have cameras. In the summertime, they needed to have extra staff to take on that 150 plus students that go through there every day. But to the issue of the batting facility, the Resident Association and the Edgehill Family Resource Center has had a number of meetings where we ask our council person, I'm too close?
Getting close to time.
Oh, okay, they telling me it's almost time. The bottom line is we've had over 2 big community meetings with the council person around the usage around this batting facilities. We have Belmont staff and the councilman to come to the resident meeting, which is monthly, to give updates on where it is. Residents has asked and requested that if this comes into place, that they have this education room. But simply because we have kids that want to be involved in sports, but they don't know the different aspects of soccer, basketball, baseball, and all that stuff. We wanted the students to actually have a place where they can go and sit down and get trained and get seminars and talk about what are the techniques of each of these things. We want year-round sports training. And with that, well, I guess I'm done, but there's so much going on, y'all. I wish we had time to tell y'all about the extended learning labs and all that kind of stuff that people are putting together for the children in the community. The bottom line, this is about, it's not about Belmont taking over property, it's about people's own personal interest, and I'm just
If I might
sick.
Yes,
stop,
Mr.
Brenda.
Greer, if you would tell
When this idea came up, Dr. Fisher came to me when I was in the council. Park was not being utilized. The opportunity for Belmont to provide facilities that the kids in the neighborhood could benefit from, and certainly what the Metro is going to do, like the other schools that come in there, it's a good deal. I went to Rose Park when they opened it up, 1963. We would have been probably the star baseball team in the nation if we'd have had something like this to work in. We didn't, and so now we do, and I think that it is a great thing for the community. Unfortunately, there are not enough kids in that area right now, or they're getting out of there because of economic relocation, but that's another story.
All right.
But yes, I think it's a great idea, and I would hope that you could approve Belmont's or the request.
All right, thank you. All right, any other questions?
Yes, actually, I do. And I'm going to address this when the other side comes back up here. Are you concerned with the limitations that Belmont will be able to place on the utilization by the community? Because I'm having a hard time with that right now, I'll be honest with you.
I would say that I don't have any objection to that. Considering what was going on before Belmont provided these services or provided these facilities, I'm not concerned at all. As with anything, you have to schedule it, and we've got organizations who want to schedule it. I don't think that would be a problem, because as the gentleman said here, I think Dr. Fisher is a very honorable man and will stand by his word.
Well,
and also, I would like to say, the bottom line is, when we got this agreement and stuff together, it was always stated that the community had first choice. And when we have time, when we have scheduled things in the past, we've always been confirmed to use those fields. As a matter of fact, there was one time when I booked the entire athletes field, all the different fields, and Belmont had a softball team that was supposed to come in that they overlooked. But on this particular day, we had the Edge Hill Community Family Sports Day, and we actually said, this is cool, y'all come on in and do y'all's game, and the kids will have an opportunity to see a real softball team.
So, to answer your question, in the same packet I have in the back, the breakdown of the amount of time that Belmont has used the fields over on the park. Now, it's a different situation, but I think it's something that we can look at to give some history to that concern. And you'll see that the fields are used anywhere from 8 to 23%, but most of that falls below that. And we have a parks representative here that can speak to that and how well that's worked out. Wayne Evans with Parks is here, and he'll tell you that Belmont normally schedules their use during the day, during the middle of the day when it's less likely for the public to be able to use those facilities, and leaves those prime opportunities in the mornings and in the evenings after school for the community to be able to use it. And it has worked really well from a timing standpoint, and I think if you want, the parks could speak to that concern.
Well, obviously, setting up what's going to probably come up on the other side here in a second, but I'm going to assume that Belmont is going to assist the youth of the community and folks like me, too, that want to go out there and break a bone or what have you. But at least try to enjoy the facilities if it meets the criteria, and I'm assuming that's what Mr. Fisher or Dr. Fisher did when he was negotiating that with the community.
Yes, the plan is to work with a particular community organization, but also any other organizations that want to be involved in youth baseball, softball, and golf.
Let me, from the school standpoint, Mr. Lawless, we have no concerns relative to us being able to use it. It's primarily for Belmont, and then as their master schedule for their baseball team, and then we're right behind there with 15, 16 other high school baseball, softball, and golf teams. And then on top of that, you've got RBI organization, as Doug alluded to, that will be also using the facility at some point in time as well.
Okay, so is there a mechanism put in place now to allocate times? Or is, as I think someone else asked you earlier, is it already set up for Belmont to have, in essence, first draw?
By the lease, they are the master scheduler for the building. That is correct.
Okay, thank you.
Yes, sir.
And I'll address that when we deliberate as well, but I will say, as a MNPS parent with a baseball player that benefits at Rose Park, it's never been an issue in my experience.
Is there any other questions for? All right, the applicant. Yeah, well, and know that the time had expired, but we also had overage from direct questions from the board, and so I want to make sure that we do give Mr. Lefevre ample time to. I mean, there's 3 minutes and 90 seconds for rebuttal, but then there's plenty of time for questions from in a dialogue.
Well, I'd like to first respond to your question about the memorandum, if that's okay, that's been signed.
Yes. I don't remember the question, but you can tell me.
I think it was a question. Okay. So the memorandum, and I think Mr. Michael can speak to this as well. That was originally adopted for reasons like portables and landscape buffers and things like that, where you had a school that ran out of space and they wanted to bring a portable and put it on to house the students. And they kept having to come before this board to say, hey, we need more space, we need to put a portable. And it got redundant that they were having to come up. Or a school wasn't complying with the landscape buffers that were required, so they had to come before this board and ask for an exception from the landscape buffers. Now, this opinion has been used once.
But wasn't it, I thought he was citing a state statute, not a local statute.
He's relying, and I don't want to speak for Mr. Michaels, but he's relying on a memorandum here from August 5th where Metro Legal opined, and this 13, yeah, and this has been used again for landscape buffers, portables, things like that, but it has also been used on a case with Overton High School, where Oak Hill attempted to enforce its zoning regulations against Overton High School, and Overton High School was able to use this and say, hey, we have this memorandum here, you can't enforce your zoning regulations on us. This was not intended to be a carte blanche. Anything the school wants to do, they can build. Hilton, what if Hilton comes to the school and says, hey, we'd like to put a hotel in your school? Can MNPS sign off on that under this opinion? I don't think anybody in their right mind would say yes, but.
Now, wouldn't that depend upon the stated educational mission? I mean, if this were a magnet school that was specifically designed to train people in hospitality, you know, I mean, I mean, it sounds like there could be arguments on both sides, but it also is, you know, if you tie it to your mission, then and there's a direct link, and it may, you know, and it's truly believed to be tied.
Yes, and I don't think we can apply it carte blanche, though. I think somebody would have to come before you and apply, not just submit a building permit under RM20 and say, we're going to build 20,000 square feet of batting facility.
So that goes to your point of the special exception.
The special exception, correct, just like they did for the original facilities in 2007, and went through the proper process there. And then to address your question that you had, sorry, Mr. Lawless, I haven't seen your face up here before.
Well, I think the matter you were talking about in Oak Hill was last time I saw you, actually.
Okay.
You were on the losing end on that, but I think ultimately I lost on that one.
Okay. But to address your point, it sounds like there is a concern about scheduling opportunity. I think I'm responding to a question here. There is a concern about scheduling opportunity, and to correct the record, there's a section in the MOU that I believe is titled scheduling. I don't have it in front of me, and it says Belmont shall be in charge of all scheduling. It's not, and there's a blurb at the end. The parties will try to work together. That's fine and good. I think we have 4 attorneys up on the board. I think everybody would agree that that's just not good enough. And while schools is saying,
there is a history of. There is a history, and it's a 12-year history of use with testimony saying that arrangement has worked out just fine.
Testimony here under that time, but
well, and a chart that showed usage.
Sorry to interrupt. Let's look at the chart from a practical standpoint. When does Belmont use the fields? When their students aren't in class. They're not going to use the fields during class time, so that's in the afternoons or evenings. When would an MNPS student use that during the school year? After school, after 3 o'clock.
But that is different from the testimony that was given. They said that it was mostly during that day that Belmont used it.
I mean, think of it from a practical standpoint. We have,
I understand that.
We have college students, and are we talking about 80% of 24 hours? Are we talking about 80% of daylight time? What is that schedule referring to?
I can clarify that if you like.
Yep, I'd love that.
That percentage is for the.
I think we need to make, we need a motion probably to open it back up.
I'm going to go make a motion. We suspend the rules and open it back up and let them give us the answer we need.
Okay.
And give them a little more time. Or we'll
All in favor of that?
Aye.
Okay. So this is simply to address the usage issue for clarity.
And the representative of the Parks Department who actually create that document that you're asking about and how it's calculated is here.
Yes, thank you. I'm Wayne Evans, Superintendent with Metro Parks. I'm involved with permitting and scheduling for athletics and all sports events. Belmont has been a real good partner for us for all these years. They spent over $9 million to build the facility. They spend 6 figures every year on maintenance. They've been a great partner. They've worked with, as Ms. Brenda said, they've worked with any community events. They'll work their schedule around that. And as far as their usage, like you said, the numbers for soccer was probably the highest one. It's probably in the low 20s is the Belmont usage percent. Baseball, much less than that.
When you say 20%?
Of the usable hours in a day.
And what are the usable hours in the day?
We usually work that from like 8 a.m. to like 10 at night when the lights have to be off.
Okay.
Yeah. And Belmont does not just use them in the afternoons. Metro Schools uses them in the afternoons for their programs. We rent it out in the evenings. Like tonight, we've got a soccer group there. We got multiple, we use multi-purpose things out there for the fields at night as well. Belmont uses them a lot during the daytime, like when they're in school. Their soccer program and baseball, they'll be out there a lot during the early part of the day or midday. I guess they can work their classes around that, but they do not take up the prime times by any means.
If there are any other questions for?
And our baseball programs, we use it way more than Belmont's teams do. And we have tournaments all through the summer. And even though they pay for all the maintenance and a large percentage of utilities, we rent it out. And that money goes back to Metro as well.
Thank you.
All right, thank you. And then,
so to continue on the response to that and to address that, I looked in preparation for this hearing last week at the Metro Parks website to see how easy is it to schedule this field. Rose Park isn't on the website. You cannot schedule it. It is now, after we alerted them to that fact last week, it is not even a schedulable, if that is a word, schedulable park until recently. So the idea that anybody in the community could just schedule this park for use, they can now, but up until a week ago, they could not. It wasn't listed, phone call to reserve Rose Park, anything like that. Looking down my list for rebuttal to see if there's anything else. So back to the legal issues. The abut for residential use, it doesn't say 50 feet from a residential structure. It says 50 feet from a property that is zoned for residential use, not from a structure. So the base zoning of the park is permitted for residential use. The base zoning from the other side is permitted for residential use. It doesn't have to be 50 feet from a structure. It's 50 feet from the parcel that has the ability to have residential use. Any other questions on the legal matters? None? Thanks for your consideration.
Okay, you don't have anything else to add? I wasn't anticipating it, but.
Yeah, I mean, I'd add one thing, and we have four attorneys, if my count is correct, on the board. And when I hear testimony like, we've been assured, and things like that, none of us would sign off on that. We've been assured that usage will be there. That's all I have.
You have 4 attorneys and a wild card, so, all right, we will, I know, I'm glad I'm not the attorney. So, all right, we'll close the public hearing because any other questions would be to the zoning administrator. I'm sorry, did you
For the zoning administrator.
Yeah, so, and we can close the public hearing and then, and ask anybody, anything on this side of the wall.
Mr. Michael, I think my question is regarding like the legal opinion. So does that mean if the base zoning is RM20, which contemplates like residential, multifamily, if the school is there, because like I live in a neighborhood that has schools and is residentially zoned, does that mean that because the school board has control of their land, that they could put a structure there feasibly that doesn't fit within that zoning classification? Yeah.
I don't think I'm not sure that it goes so far as use. And in fairness, that's not a situation that's before the board today, I don't think. But the guidelines that I read through when I looked at our opinion, looked at the case law that's cited, looked further at the sections of the state statute that are cited, really seems to contemplate zoning regulations like bulk regulations, which is what we're talking about here is the setback question, height restrictions, landscape buffers, driveway widths, numbers of loading docks where applicable. Those sorts of things under all of these cases, under the AG opinion and under the statutes, typically don't apply to the local school board owned properties, owned and operated properties. To your question, which is impliedly, I guess really just more of a traditional use question. If the use is not allowed on a permitted conditions basis or by right or as an accessory, whatever other structure, by special exception perhaps under our local zoning ordinance, it's probably not going to get there because I don't think it goes so far as to use. Mercifully, that's not the question, the operative question before the board today because that might be another opinion from another lawyer on another day.
Thank you.
All right, I've got 4 lawyers. What are your thoughts?
Well, I think that there's, I think the community has benefited by this facility, and I know the other side may have disagreements about use in the future, but to me, that's really not the issue here because this is an item A appeal. So it's all about, did the zoning administrator err as a matter of law? So the under the zoning code, if this facility is for community education, then it's okay, and the zoning code is broad. But I think what the zoning code contemplates is that the main purpose of this facility be for community education, and I don't think it is. I think it is an athletic facility for a private university, and it will benefit the community. But again, that's not part of the item A appeal. With regard to the setback issue, I just don't, there's nothing in our materials. I didn't know that was coming up. I haven't seen the case law the zoning administrator is relying on it. I think that it sounds like that case law is not right on point. There's some wiggle room in that, so I really can't make a decision based on the setback, but I think the zoning administrator erred because my interpretation is that the main purpose be community education, and I think there is some connection to community education, but it's an ancillary secondary connection, and for those reasons, I think that the zoning administrator erred.
So I guess where does it, and that's interesting because, so you're saying that MNPS and erred because it needs to go through a special exception process, or erred because?
I think the accessory use needs to be primarily for community education under the RM20 guidelines. If it's for community education, then it's okay. And community education is defined as means instructions on an elementary, middle, and high school level approved under the regulations of the state. And so I think the spirit of this accessory way to do this, for lack of a better word, is that it be primarily for community education.
Community education means the school.
I will concede there's room for interpretation here.
And and I guess and my only, and again, I like it when someone has maybe a different point of view because I learn from it and I appreciate it. But how is that test not met when the school board passed it, and the school board and the principal of the school the school board passed it, and that was a signal to us that they felt like it was for their educational purposes, and the principal of the school wrote a letter saying, I think this is for educational purposes. I mean, what basis do we have to say it's not for educational purposes?
I think that's their opinion, but I think we're the arbiters of that. It's for us to decide, and what is coming through clear to me, and I read all the materials, is that this is the primary purpose of this facility is a sports facility for a private university. And I think that I'm not saying that there's not some educational benefit at all. I think there could be, and there will be. But I think that that's not the primary purpose of this accessory use. And so.
And Mr. Chairman, I think Mr. Pepper has it absolutely correct. No matter how noble this is, and I believe it's an incredibly noble thing that's going on out there to educate, at least in sports, but that's not education of elementary, middle, and secondary. It's not school. You can't, I can't take it that extra step. With all due respect, I think we might have missed it on this one. There's other ways for them to accomplish the goal.
So if the softball field had been on school property and they'd built it for themselves and for Belmont on their property for their ball field, would it have been acceptable or no? The fact that Belmont uses it at all?
Well, but Belmont has.
I'm sorry to interrupt, but because I want to understand what you think the proper process is. By saying you think the zoning administrator erred, are you saying that you think that they should have asked for a specific special exception for this?
I do.
Okay. That there's a path for them to have it, but it's through the special exception process.
They missed the path. They took the wrong exit from the interstate.
Okay.
And in this instance, this is really a primary benefit to a private university, in my opinion. And it may be, I've been instructed and told I don't know what I'm talking about before, and I'm sure it'll happen probably this night when I go home. But the fact still remains, it's primarily for the benefit of Belmont, and they control the scheduling, which I think everybody heard today I had a huge concern over. They don't meet the criteria, as Mr. Pepper put out there, for really educational. We heard no testimony. There's nothing in the package that says, okay, we're going to teach them the fundamentals. We're going to teach them, the history of, and all those other things. We're going to teach them, we're going to take the adult population from the community and good health parts to it, and those types of things. That, to me, would have been better. No, they've got a sports facility, and, I can't get over that hurdle. And again, they could go in and get a special use exception and go forward there. It would have been just as easy, but now they've already started building it. Is the horse out of the barn? I don't think so. So it may not be a good reasoning, but it's the only reasoning I can come up with that I had trouble with it. And I want this facility for them. I just don't think they're doing it the right way.
Any other thoughts?
I'll weigh in. And this is why people love and hate lawyers. I disagree with my colleagues because I think it is clearly for an educational use. I think the statistics we've seen and the testimony we've heard from the parks representative, it's not primarily used for Belmont. In fact, it's not even half of the time used for Belmont. And therefore, I think under the broad definition of community educational use, I think we meet that standard. I would also submit that to me, and maybe this is different, I don't think education requires a teacher giving a class. I certainly think education can be with team sports or with other sports where you have a coaching perspective and not necessarily a teaching perspective. Now, that's just how I see that particular definition. We're not here to talk about whether the understanding is appropriate or whether it meets our legal definitions necessarily. That's for another day. But to me, I just don't see how the zoning administrator erred looking at what we've done for the past several years. And we also have the situation here. We've got a years-long standard and pattern of these fields being, or Rose Park being used without problem. And barring some really strong evidence to the contrary, I can't find that the zoning administrator erred, and particularly when I think it is an excellent use of public resources for a real benefit for Metro schools.
I think I'm over here just thinking about both sides. I don't know, I'm still mulling whether to take a more narrow definition that Mr. Pepper and Mr. Lawless have advanced or a broader definition that Ms. Chappelle just advanced, because I do think education happens outside the classroom. Education, that's why there's parks beside schools, that's why there's playgrounds, because education is not just in the school education. That's why they encourage kids to play sports. That's why, I think education doesn't have to be so narrowly defined. And at first I was with Mr. Pepper, and then as I listened to both sides, I'm sort of still mulling, I don't know, based off of the arguments presented, if I can get over the hump to say that the zoning administrator erred based off of that, the reason that he granted the building permit. So I'm still listening. So, Chairman.
The non-lawyer, that was one of the reasons that I really wanted to hear more about what you were saying, because my initial reaction is really more in line with Ms. Chappelle. And thinking that if we have testimony from the people who, from MMPS, from the principal, from, and those are to me, those are the most important testimonies, because that's the landowner who's building this facility with another entity. And they're saying, yes, this meets our mission. And I haven't heard any testimony from anybody saying it doesn't. And yet, I think that the comments that Ross mentioned are compelling too. So I was like, okay, well that needs some additional thought. But the ultimate question is, did the zoning administrator err? And to me, it goes, it may hinge on, that understanding from Metro Legal of how schools can build it within their property. And I think that we haven't heard anything that suggested that that was incorrect. I mean, we did hear from the appellant talking about the history of that in terms of trailers and landscape buffers and that type of thing. But we also heard testimony from Metro Schools saying that it had been used before, that this wasn't the first time that they had used that memorandum of understanding or that letter from legal. I think y'all know what I'm talking about, right? And so to me, those are the two things that have me really leaning toward supporting the zoning administrator. Because ultimately, it did the zoning administrator err. The 2 points that the appellant made were the RM20, and to me, I think once it's a school, it goes to community education. And the only point I wrote down on that was the setback, and it really wasn't the educational use. I mean, I think, but yet even, and the setback issue, I tend to edge toward the zoning administrator, but it's not an easy.
Well, I thought the appellant did a really good job laying out the legal arguments, and initially I thought the RM20 was going to be a reason why I was with the appellant. But then when the zoning administrator told me that that's not really the question before us, and that we don't really have we're not weighing in on that, that's sort of why I'm sort of now leaning towards you and Ms. Chappelle, because the question is, did he err? And I don't know if I believe the zoning administrator erred based off of the reasons cited.
And I guess, you know, when we have an item A, there's all kinds of issues like, and again, that were raised that I'll acknowledge because I'm not on that side of the argument of some folks may be feeling like that they didn't have full participation or that it was railroaded or what have you. And I understand that frustration, and I'm very empathetic to it. And when things don't feel fair, I don't like it. But on this, and I don't think that happened in the zoning administrator's office. That all happened in another venue. That was MNPS, and that was other community forums or what have you that was expressed. So I get that, but the question now is, did the zoning administrator err or not? And I guess somebody needs to make a motion and see where we go. Well, you know what? Well, here, the way the rule works is, and all right, we'll have to ask our lawyer, but in any motion has to have 4 votes to pass, but we're voting to overturn the zoning administrator, and so if there are not 4 votes to overturn the zoning administrator over a period of 60 days, then the zoning administrator is upheld. 30 days. All right, sorry, I thought I got that. I got it almost right. For the non-lawyer. So anyway, I'll move that the zoning administrator did not err.
I'll second.
I have a motion, I have a second. Any discussion additional? All in favor of that motion, say aye. All opposed to that motion. So that motion had 3 votes for, 2 votes against.
So that motion will stay open until the next board meeting. Oh, well, I mean, unless you want to make another motion.
Unless you want to make another motion, and that's what I was, yeah. That's all I have to add.
That motion failed to receive 4 affirmative votes. You can make another motion and see if it does receive 4 affirmative votes.
So we have a motion. Do we have a second? I have a second. So we have a motion that the zoning administrator did err. All in favor of that motion, raise your hand. All opposed to that motion, raise your hand. So that motion failed 2 votes to 3 votes. So both motions are on the table, or both motions have been made, neither passed.
Right, leave it on for 30 days, and, yeah.
And she can hear, and, right.
Yeah, Alma can review that.
And then if we need to we wouldn't reopen the public hearing, but we could reopen discussion, and if there's additional thoughts, then that can certainly be weighed then.
That's correct.
All right. Yeah, short break, and we will be back in 5 minutes.
to you by 6 o'clock.
And per our rules, if we are not able to hear your case today, it will, in the order that it is on this docket, go to the front of the next docket, and you won't be at the end of the docket.
That's right. So the next case is case 2019-408. This is a case that was heard at the last hearing, or at the last meeting, rather. It's involving a variance from street setback requirements at 1610 Gray Bar Lane. Ms. Chappell, did you have an opportunity to watch the video for this?
Yes, that's why I was calling.
And are you prepared to vote on that?
Yes.
So the motion that was left on the table that failed to receive 4 affirmative votes was a motion to grant a variance for a 105-foot setback.
Yeah,
So I believe-
yeah, and that was my motion, and I'm going to withdraw my motion and allow another motion to be made.
Withdraw your motion? So we'll start from scratch with respect to the motions.
I think that, yeah, yes.
So is there another motion?
Well, and I'll tell you, I mean, the council member, and you're very sensitive about information coming to us after we've heard from both sides, but council members by rule can basically weigh in when they choose. We did get a letter from the council member initially supporting, but now saying that based on the neighborhood communication with the neighbors, the council member was against this variance. And because the house sits now at 135 feet, by code, it can go to 120, that's 15 feet. Based on my hearing of the case, I felt like 105 was a fair compromise but since the council member has come out, and I've kind of relooked at this knowing that they have an additional 15 feet from where they are now, I withdrew my motion and am happy to allow someone else to make a motion.
So knowing that, I'll move to deny the variance request.
I'll second.
I have a motion, I have a second. Is there any discussion? Any all in favor of that motion, raise your hand, say aye. Any opposed? That motion passes. And one abstention. All right, case 420.
Next case is case 2019-420, involving property at 3815 Hillsborough Pike. This is a variance from sidewalk requirements to replace existing tanks, lines, and a dispenser at a gas station without building sidewalks or paying into the fund. There was opposition here earlier, still here. So each side will have 10 minutes. Before you is a zoning map. The zoning of the property is SCR in this district. Aerial photography showing you the property and the surrounding area. This is the site plan submitted by the applicant, and finally the photograph showing you the current conditions of the property as well as up and down the street. So the applicant will have 10 minutes to make your desired presentation. Please be sure to identify yourself by name and address.
My name is Christy Strauss. I'm at 12970 East Tux Chapel Road in Rogers, Arkansas. I'm the liaison for 7-Eleven for this project. We've applied for the sidewalk variance in regards to the size of the site and the work that we're going to be doing, which will be removing and replacing the existing tanks, lines, and dispensers to bring the tanks and equipment into compliance. And with that, we currently have 5-foot sidewalks. And when we presented this, the planning staff recommendation was that they approved it with the conditions, and 7-Eleven has agreed to all of those conditions.
Okay.
So
you agree with the planning conditions recommendation, right?
yes.
Okay, so well, we're here, but there's opposition, so we just probably need to hear from, you don't have anything else to add
No.
other than that? Okay, so we'll hear from the opposition.
Okay.
And then you'll have 9 minutes to rebut.
Thank you.
All right, if you would state.
Yes, sir. Am I ready? Sorry. My name is Ed Cole. I reside at 3022 23rd Avenue South in Nashville in the Green Hills area. I served as president of the Alliance for Green Hills, which is an organization made up of developers, business owners, and neighborhoods in the Green Hills area trying to look at the future of Green Hills and making it a better place to live and to shop and all of those good things. We were we as an organization are unanimously opposed to the variance that was requested. However, in talking with our council member and in follow-up on that conversation, we are not aware of any of the conditions that the planning department may have put upon the variance.
Yeah, sir, let me tell you, the planning department says the applicant shall contribute the in lieu fee for the property frontage, coordinate with Metro Public Works with regard to installing a 5-foot clear sidewalk around the existing NES power poles at the southeast corner of the property, maintain existing sidewalk conditions in a state of good repair per Public Works final guidance. Any portion of the existing sidewalk along the property frontage that is not ADA compliant is to be removed and replaced with in-kind with MPW detail ST-210 sidewalk. I guess that means what it means. If the site is redeveloped or sidewalks are triggered in the future, the redevelopment or site improvement shall incorporate appropriate site work to construct a sidewalk which meets the major collector street plan, which basically means that they don't have if they renovate in the future, this isn't a permanent variance, this is just for this project. So if they come along and do something else, then they're going to have to come back and either address us or not. So that's what the planning staff recommended, that they pay and basically keep in good shape what's there.
And they have agreed.
And they've agreed to that.
To those conditions.
Yes.
I think based on that information, I would withdraw our opposition. I think this is a good move. I wish we had heard it ahead of time, and we're sorry to have taken your time to have this information conveyed at this meeting.
Great. Thank you.
Thank you.
Can we go into
And ma'am,
private?
you have rebuttal time, but is there anything else you would like to say?
No, that's it.
Okay. Then I'll move that we approve the
I'll
variance.
second it.
With the planning department's recommendation.
Yes.
Have a motion, have a second. Any discussion? All in favor?
The only discussion is that we have a council person who's strongly opposed who wrote us a letter that I read while I was
He did.
away for an hour.
Yeah, well, that's right. And he, that is a good to note, and was not opposed to it remaining on the consent agenda, but wanted his opposition noted, because I do think he wants at some point things to go up to code. And it is noted, yeah. So is that?
No, I was just pointing it out because we're
Okay, good.
operating really
To note for the
quickly.
record.
Yeah.
Okay, awesome. Okay, so we have a motion, have a second. Is there anything else from anybody? All in favor, say aye. And opposed? That motion passes. Next case.
2019-423 involving property at 816 E 19th Avenue North, requesting a variance from sidewalk requirements to construct 4 townhomes without building sidewalks or paying into the sidewalk fund. Zoning map before you shows the zoning of the property as MULA. Aerial photography giving you a sense of the surrounding area. Site plan submitted by the applicant is before you now, and finally, the photograph showing you the current conditions of the property as well as up and down the street. Is there anyone here in opposition to case 423? Seeing none, the appellant will have 5 minutes to make the desired presentation. Please be sure to identify yourself by name and address.
My name is Duran Jenkins.
Just press that button and make sure the red light's on.
Sorry.
There you go. No, you're fine.
Hello? Yeah. My name is Duran Jenkins. I live at 1210 Gartland Avenue. I want to first start off by saying that I've owned this property for 10 years. When I purchased this property, there was only one pole on this property. It was an NES, the normal wood pole. I paid NES $3,500 to move the pole to the property line because it was in the middle of the property. Obviously, it's going down. If you look at the other picture, you'll see it it's even on the far left. So it's not in the picture, but it's on the property line between my property and the duplex that you see. So I paid $3,500 for that. Approximately 2 years ago, I got a call from the guy who cuts my grass on my vacant lots, and he told me that NES, or there was a pole or something laying on my property, and he couldn't cut the grass. So I went over there. And they were installing a pole, that big metal guide pole, on my property. At that particular time, I actually tried to get in touch with the supervisor. Of course, I wasn't notified. After digging more into it, I learned that NES is actually supposed to communicate with Public Works and for the placement of poles. for these reasons sidewalks so that, it would fit either in between the grass strips or in a particular area. They did not do this. They just sat the pole. I actually would have liked to be able to do the sidewalks. I went to Public Works, talked to Rowan, very extensively about it, and he just there's really no way to do it. The in lieu fee is like $9,500. Because it's,
Now, why can't you build sidewalks? I mean, I know the pole is there, but you got a porta-john that is about the same size as a sidewalk.
There's not enough room for the sidewalk and the current strip.
Well, I know, but you could, but there's always, I mean, we could give you a variance for an alternative plan where you have a grass strip up to the point where the pole is, and then you kind of cut in. I mean, that's something that.
Well, I've talked to Roy. I'm sorry. Go ahead and finish.
I'm sorry.
Well, I've talked to Rowan is the person that does the sidewalks and stuff, and he actually met me out there and measured, and if I moved the sidewalks behind the pole with the strip, then the sidewalks would actually be on private property.
All right.
If you move them in front, then obviously they're in the street and there's not enough room. So I asked him, was there a way to alter that, and he said it wouldn't comply with their standard sidewalk codes.
Right, but that's where you'd come to us, and we would allow you to. Is that right? I mean, we could allow the opportunity to not comply on that section. That's part of the variance.
I love when you ask the questions over there.
It tells you how much confidence I have. It's like, I think I'm right, but I need to look over here at the authorities to make sure. I know. Yeah. So that is an option that we could do, is to say, well, provide the sidewalk with the grass strip up to the point where you need to, in the upper left picture, go where the, porta-john is, and it just kind of weaves over there without a grass strip or with a minimal grass strip, and I think that's something that we certainly have the ability to do.
I mean, I'm open to doing that. I don't have a problem with that. But like I said, I spoke to, Roy, who is over sidewalks, and he was not comfortable because obviously after I build it, then Metro has to maintain it, of course.
Right.
And he wasn't comfortable with it. He actually was supposed to get me a letter to actually bring, but he's very busy.
Yeah.
So he couldn't. But I mean, that's the situation that it was. And those other buildings next to it are actually zoned industrial. So they can have a zero, their property can sit like right on, if you look, theirs are actually closer than mine because they actually sit on the property line. So, I mean, it would be difficult to do a continual sidewalk in either direction. And then, like I said, the in lieu fee is $9,500, which is probably 2 times, almost 3 times the amount to put, curb and gutter on 60 feet.
Okay, so your preference would be to have us allow you to do an alternative sidewalk design that you could fit with your property than to pay? I mean, if we were not to just say you don't have to do anything.
Yes.
Okay. Any other questions? Do you have a question? Nothing about a question. All right, did you have anything else to add?
I do have a question. So what if, I mean, I don't know what your decision is going to be, but what if there isn't a plan? Like, what if we can't come up with a plan? Then do I come back again? And you know what I mean? Like, if someone goes out and assesses, whether it's whoever is in charge of the sidewalk to instruct how it should be, if they go out and they say, well, this is really not a good place, this pole is, because it's slapped. I mean, the pictures really doesn't give it justice of where it's really truly located, because there's so much stuff out there. But if you were on this site, you would see how humongous this thing is. Yeah. And it literally, and on the other side of that pole is actually the driveway into the property as well, which he also took that in consideration when he even said that in the beginning. So it's just tough. But like I said, I mean, if there's some way that it can, I don't know, because it doesn't have sidewalks on the top of it either. And in order to build it, there's actually a retaining wall that I had to build on the other side, on that far left, on the left side, where the duplex is. You really probably can't see it, probably better from the other direction. But like I said, I'm open, but I truly don't think there's going to be a way you could do it.
Okay.
You've got a water main, a fire plug,
Yes, sir. That's also there.
so it's where.
Yeah, that's what I'm telling you.
I just noticed that in the picture. Okay, so you got the pole and the fire main. Yeah, okay.
So I'm
going to let the chair how to word this.
Okay, I'm sorry. Susan, did you?
Go ahead. I was just going to say, this is, again, one where you can look at the, whether or not there are some hardships here and you want to grant a variance or not as the initial part of your analysis, and then decide how you want it mitigated if you choose to allow for a variance. And what I'm hearing the board say is that you want some sort of sidewalk here, but are flexible as to how that design looks in light of what you see here. To answer the question for you that Mr. Jenkins has posed, the item would come back to you if it needs further clarification. So if he goes to Rory and Rory says it can't be done this way because his permit is from you, he would have to come back to you to get that adjusted. I think there is a fee for coming back to you all, but I think under those circumstances, you could consider, waiving the fee in that instance because he's trying to do what you've told him to do. So I think that's how that will work, what that will look like.
Because I'd have to come back again and do this process again.
Right.
Essentially, if Rory or whomever says, hey, you can't, then I got to come back again, and then at that point, where do we go again?
All right. Sir, did you have anything else to?
No, sir.
And Rory's going to love me for this, but you can also require someone from Public Works come to give you input as to how it can be done.
Be mad.
All right. Is there any other questions for the applicant? Did you have anything to add?
No, sir. I do have a question. So what are we actually deciding? Or are you deciding?
Well, you've asked for a variance on the sidewalk requirements, and so we will decide if you met the criteria for a variance, and then if you've met the criteria, then we have to decide, do you pay the in lieu fee? Do you develop an alternative plan? Do you pay part of the in lieu fee? Do you not pay anything at all?
Okay.
And then we have to decide that part. And so depending upon what we decide, you may have to, if we say an alternative plan, it may mean go to somebody else. So,
Okay.
so I will close the public hearing. My thoughts are maybe that the applicant has said he'd like to have a sidewalk. I'd like for him to work that out. But if he can't work it out, I'm almost inclined to say, pay for 25 feet, which are 20 feet, which would be about the cost of the sidewalk. So either way, he's paying for a sidewalk, and if to me, that gives an incentive for Public Works to say, well, let's figure out how to make a sidewalk. We can actually have a sidewalk, but if they don't, then he's out the same, but not the extra. But that, some of y'all may want to.
He has 50 feet of frontage, it looks like.
60.
How many, you got 60 feet of front?
Yes, sir.
Okay.
So 7,500 would be that.
Oh, it's 63, but yeah.
But I think that to me, there's a clear,
There's
hardship,
a hardship here.
hardship.
You've got two hardships. You got NES popping a
And
pole,
so-
and you've got,
and they all seem, it's not, but at the same time, if it was a ditch, then we'd say, well, maybe pay something because
we got it. A sidewalk would really be helpful to the people there, but he didn't create the problems.
Exactly.
They arrived on his doorstep all of a sudden, and I don't mind him. I don't know how to word this one, though. This was a little more.
Well, that's where I was
peculiar.
thinking if you
do a special.
Well, I would just say, doing.
Well, the hardship we know is there.
Yeah, I would say there's a hardship for a variance. So if I were.
If you were doing it.
Thinking through a motion, it would be that he work with Public Works, and you work with the appropriate folks to develop an alternative plan. If they can't develop an alternative plan, then whatever it would cost him to build the sidewalk, which he said is about a third of the cost, which is about $3,000, and he would pay for 20 feet of the frontage, which would be the cost of the thing. So basically, it means he wouldn't, if it ended up being a frustrating process where they couldn't work anything out, he's saying, well, fine, here's the money I would have paid for a sidewalk to the fund. Not the whole in lieu fee, but just the cost. And so to me, that's an incentive for Public Works to say, well, let's, we'll either have the $3,000 for the fund or we'll have a sidewalk.
And that's my motion.
All right, you made that. So you made that motion. All right, that's fine. Good. And you seconded it. All right. Any other discussion?
What I'm going to say is that there are 4 townhouses being put on this property, so that's a lot of building being put on this property.
Right.
So it's not like a single-family home that's being put on this property. So I think it's a little bit too lenient, but I will support it. I will support it because it's doing something.
Okay. So we have a motion, we have a second, we have a comment, and any other comments? All right, all in favor, say aye. Any opposed? All right, that passes. I don't know if you understood that motion, but it basically means if you can work out an alternative plan, great. If not, then you will.
But I mean, it's just not fair, though. I mean, I didn't ask NES to do it. They just put it there, but then you're going to make me pay money just because? Like, that's ridiculous.
Now, what
when I already paid $3,500.
Yeah.
You have an option you didn't have.
Yeah, you have an option. Didn't have it. The motion was that you can build an alternative sidewalk, which you said you would do, and if for whatever reason you can't work that out, then you have another option to get out of that. So I think that's, anyway, we unanimously agreed that was fair and good, so, and I hope it is. So, next case.
And to confirm, that was to contribute 25 feet in lieu if he can't come up with a plan, is that right?
Yeah, 20.
Yeah, it was 25 feet.
20, yeah.
Okay, wanted to make sure we got the motion correct, or the order correct. Next case is case 2019-427 involving property at 43 Wharf Avenue. This is requesting variances from side setback, parking, and lot size requirements in order to construct 2 single-family residences. Before you now is a zoning map showing the zoning of the property is R6. Aerial photography showing you the property and surrounding area. This is the site plan as submitted by the applicant, and finally, the current photographs of the property from a recent site visit. Is there anyone here in opposition to case 427? Seeing none, you'll have 5 minutes. Please make sure to identify yourself by name and address.
All right, thank you. I'm Eddie Latimer again, and with Affordable Housing Resources. We have been working with Auburn University. Auburn University School of Engineering has had a program called Rural Studio, and they've been developing homes under 600 square feet that they can pay the electric bills down in South Alabama for $25 a month. And it's just due to the way they're designed and all. Auburn decided to expand this program, and we're the only urban environment where they're going to be building these homes, and so we won the bid. So I just wanted you to understand what the product is. We were also won these 2 lots on Wharf Avenue from the city through the Barnes Fund, and they are a little problematic, so we're going to just see if we can work them out. So we're asking for 3 things. We need a lot size variance that allows for, there are 6, but the lot, you need 6,000 square feet. We only have 4,500 square feet. The lots are 30 feet wide. They're the normal depth.
And so, sir, you're presenting a site plan that has 4 homes, but it really is on 2 different lots. Is that right?
And so what happened, so I'm just doing 1 lot now because apparently there was a filing error. So we're going to be back again to do the other one.
Okay. And
So the application was filed with staff, but there was an issue with the notice requirements. Apparently didn't get mailed out, or we didn't receive evidence that they got mailed out. So he's gonna send those notices out, and he'll be back for the other parcel.
So are both parcels the same size, or both of them?
Yeah, they're both 30 by.
So you've got 8,000 square feet total?
Total.
Between the 2?
That's right. 9,000. 9,000.
And I know we look at each of them separately, but you are building a
little commune, a little commune kind of thing, with picket fences and gardens and everything else.
But it'll appear as if it's one development, even though it's on 2 pieces of property.
Exactly.
And we have to look at each property separately.
I understand that. And so we are asking for the lot size variance. We also are asking for a side setback from 3 feet to 1 feet, but only on the side of the lot where we own the adjoining lot. not on the neighbor's side. And we're also asking for a parking reduction from 8 for the 4 units to 6.
Mr. Latimer, is there a hardship here other than that it is affordable housing? Because I was looking at the application. Let's see, yeah. Is there a hardship besides it's affordable housing?
Well, I wouldn't consider it a hardship. It's just an R6. So instead of the city asked us to build 1 home, we can get 2.
Okay. Well, I guess maybe I'm not asking right. What is the hardship? And maybe I'm not hearing it right.
Well, it's only 4,500 square feet per lot. So in this and we want 2 homes, which the code says, Mr. Michael, if I'm not right, I think it says you got to have 6,000 square feet.
Right. So
that's the hardship.
So are you saying a special exception might be a better ask? Or
it might be a better ask. I mean, we can't consider it being affordable housing as a hardship. And I'm just trying to, if there's a hardship.
No, that's not a hardship. I agree.
Okay. If I'm trying to figure out what the hardship is.
The square footage.
I mean, I think that, I don't have an issue with the hardship on the side setback because of the nature of the project. I mean, it's the nature and the effective side setback is much further than a foot the way you've developed the site. So, but I agree that the lot size hardship is a little bit harder to define, even though the project looks like a really cool project for the city. And so that's why I think I was saying, is this a special exception?
I don't have a problem with the parking going from 8 to 6 or 3 to 1, because I think when it's close, that's kind of within the lot size I do.
The lot size, you're going to have 4 units.
On 9,000 square feet.
On 9,000. And notwithstanding, but wouldn't special use be a better way?
Is there a hardship path that may be more obvious to?
The request is for a variance because a variance is the path to get permission to operate on this smaller lot size, to get the setback reduction and to have the parking count reduction. There's no special exception path under the Metro Zoning Code that gets you to these outcomes that are sought. It's a variance, it's required. And by law, in both the zoning code and state law, which enables the board's actions, that requires the determination of a hardship of some sort, associated with the land, of course.
And then do we know if there are adjacent properties that are bigger? Well, it looks like the one right across the street has 4.
Looks like the 2 immediately to the right are both 30, and the one immediately to the left is 30, and then the one next to that is 40. The ones across the alley are all 40,
So it's not uncommon in that neighborhood or that street to have a 40-foot lot, which would be eligible for 2.
On this map, it looks like it's about 50-50, so not uncommon. I don't have any, this is all I've got before me. I don't know about further up and down the street.
Okay. Can we see the overhead again, please? So are your 2 parcels where the red dot is, both of those, or just is that one, is it half of that, and then there's another half not developed?
That, where the arrow, the bottom part of that red dot is the 41. There's another one below it, which is 43. Below it is 41, and then there's another lot that's on the side street.
Yes, I understand, I'm sorry.
Okay.
I don't know which is 41.
So that it's the one below it that we'll be hearing next, right? Is that?
No, that's someone else just bought that a couple of months ago.
So it's the one in red is the one we're talking about today?
Yes, and then the one right below it
is
the 41.
Okay.
So I'm sorry, I'm unclear. So are we talking just about the one in the red?
Yeah.
Okay,
And we'll hear the next one
another time.
yeah, because of noticing issues.
You were asking about a path forward, just because this is a night when we like to reference older legal opinions. Why not reference one today on this? So we have one from Brooke Fox when he used to opine for the Board of Zoning Appeals, and just to help the board a little bit along maybe. The BZA has the power to grant variances, but it does not have the power to rezone property. And so you can grant a lot size variance to the extent that it's not tantamount to a rezoning. You can grant a lot size variance such that it does not substantially impair the intent and purpose of the zone plan or the zoning ordinance. So those are kind of your parameters for lot size variance. It's not a whole lot of guidance I can give you really beyond that. But that's what we have opined in the past. Yes, you can do it, but you kind of have to be careful about doing it because you don't want to undermine the zoning code.
And so if in the past we've said that if property were close, and close is something that everybody can weigh what that means, and it allowed the property owner to have the rights that their neighbor does, substantially does, we have voted those, and we've also voted down those that were close that gave them rights that their neighbor doesn't have. So, I mean, we've had a case where it was close to having two homes, but none of the others around it could, and so we said no. And then there are some that were close to being able to have two homes, and all, a good majority around it did, and we said yes. Some of those had screwy lines and some didn't. This one seems to be a pretty nice looking rectangle. But is that an appropriate analysis or argument or approach?
I don't have a criticism of that approach. I think it would be interesting to know, if we know, and I don't know that we do, what the zoning is kind of in the area. I see OR up at the top. Is it mixed? Okay. Is there anything that else that is around it that's R6 also? Okay. So again, I don't have a criticism of that approach.
Okay.
So I sort of agree with Mr. Pepper. Like, I think this is a very cool design, but I don't see a hardship. Like, I need some help seeing what the hardship is. I don't have a problem with the parking variance, because that's not that big of a variance, or even the side setback. My main one is the lot size, so that's where I don't see a hardship.
And so the alternatives would be an SP, or which ends up being.
Let me just ask this, just while we're discussing. How do we feel about if we did 3 houses? I know we still, but if we look at it in terms of a whole parcel, can we think of it that way? And do 3 instead of 4? Is that doable?
Are you talking about the other parcel that's not before us, that's going to come before us?
Yes,
Okay.
if we waited, if we put them together. I'm just,
Right, yeah.
in talking out loud, if we think, and we're looking at it down the road, but I guess you still, if you have a co-owner, can one of the units sit on 2 lots, would be one of my questions. Can you have 1.5 houses on 1 lot if you own both the lots?
And maybe
it goes back to planning.
If you own both of the lots, but it does, I think it creates some mapping questions with regard to that. I'd have to research. I know you can do it. I mean, a person could do that. And we have houses set like that all over the city. They often sometimes pose mapping questions. And so I can't encourage you or discourage you to do that without talking with planning and mapping to see how that's going to affect them. I can say, I think we're limited today to the parcel that's before us. in terms of making a decision. Now, if the applicant is willing to defer and put both of them on the same agenda, perhaps you can have those
But now
kinds of conversations.
but isn't there a unique circumstance clause too? Because this isn't, I mean, is there, because to me,
Are you talking about for the variance?
well, for the lot size, because, you know, you're talking about two 600 square foot houses where someone could build a 1,200 square foot house with not even coming here. And, you know, and to me, that it's one of those things where they're presenting something that is different. I mean, this is not a typical residential request. And I don't know that the property is specifically different, but I think what they're building is proposed to be different. And to me, that's what separates it from somebody just saying, hey, I want to build, you know, two tall skinnies on Second Avenue, 3,000 square foot each, and I'm 1,500 feet short.
I'll try to answer what I think is the legal question here, and that is, what about the catch-all piece? The catch-all still has to be tied to the land. It's still a function of the variance criteria under, I believe, under physical features of the land. I need to reference the code to double check and make sure, but I believe it still has to be, it can't just be a catch-all for any reason. It has to be a catch-all that is tied to the land.
So, I mean, are we struggling with this because it's a very noble, very unique project, but yet are we opening up a slippery slope when someone else comes in with a unique project? I mean, yeah, I'd like to say go with it, but I'm having a hard time when they have four of them, because we're going to see all four, and we're now 3,000 square foot, or the lots, we're talking 3,000 instead of 75%. And I'm having a real tough time going that far, no matter how noble the deed is.
Well, if we take the deed out of it, the noble deed out of it, though, if you look across the street, you know, that where the property is just 10 feet wider, there are 4 units right across the street that we can see from the overhead. I don't know if that gets us there. To me, I think we don't have enough information, and I'm inclined maybe if we want to think about getting them all on one docket.
So the other property would need to be on the first meeting in November in order to meet the legal notice requirements. So to the extent you'll want them on the same docket, that would be November.
Did we close?
I think.
I will close. I'm sorry, sir. Did you have anything else to add? I know we've gotten into trying to figure this out and may have left you out the opportunity to say anything else that you wanted to say. But it sounds like we'd like to hear them together, and that the struggle we're having is the lot size hardship.
Well, no, I understand what you're saying, and I got to come back anyway.
Right, so that's all right.
It's not going to lose another Thursday.
Right. So you're okay with the deferral of this case, so we can hear both of them at the same time?
That's fine.
All right, so I'll move that we defer this case.
And I'll second that very quickly.
And then, that we will move I'm not sure what number the next case will be, but we will hear both of those in the order of this first case.
And
towards the front.
Yeah.
Thank you.
I'm sorry,
yeah, I was just going to
I'll
say,
take it.
I pulled the code now, and just wanted to confirm with you that is under physical features of the property. It talks about the property, the exceptional narrowness, shallowness, or shape of a specific piece of property, exceptional topographical conditions, or other exceptional or extraordinary condition of the property such that it will result in a peculiar and exceptional practical difficulties to, or exceptional undue hardship upon the owner of such property if the strict application of the regulation enacted by the ordinance and codified by this title. So that catch-all is in the 174370A physical features of the property.
Okay, so if there's something unique about it in relation to where it is also, okay, is a potential.
Right.
Okay. All right, so we have a motion, we have a second. All in favor of deferring this to November 3rd? Okay, we'll see November 3rd.
Thank you.
Next case, 2019-429, involving property at 82 Fain Street. Is the applicant here on case 2019-429? Go ahead and come forward to the table, please. This is involving property at 82 Fain Street, a request for a variance from rear setback and sidewalk requirements in order to construct a single-family residence without building sidewalks or paying into the sidewalk fund. Before you is a zoning map showing the zoning of the property is R6A. Aerial photography showing you the property and surrounding areas. This is the site plan submitted by the applicant, and finally, the photograph showing you the current conditions of the property as well as up and down the street. Is there anyone here in opposition to case 429? Seeing none, the appellant will have 5 minutes. Please be sure to state your name and address before making your presentation.
My name is Joseph Martin. I live at 146 Fain Street. As far as the sidewalk part of that, I guess there's not a whole lot of information in what the lieu of construction fee was going to be. I didn't receive that before this meeting.
Are you willing to pay that?
What is it?
It's $152 a foot. So if you have a 50-foot lot, it's about $7,500. Or you can build a sidewalk up to the...
Up to codes?
Yeah.
I guess if I change the way that the sidewalk is now, does that change where the start point is for the setback of the house?
I don't think it has anything to do with the setback. Yeah, it doesn't have anything to do with the setback. Setback's from the property line. It doesn't have anything to do with the sidewalk.
Okay. At that point, I would want to, I guess, price out, upgrading the sidewalk versus paying the fine.
Okay.
Well, if the...
Or not the fine, in lieu of,
If the board grants a variance on the condition that he contribute to the fund, that is just another option for him. He doesn't have to decide that now. He can determine at a later date what the in lieu contribution would be, and if he chooses to exercise that with this board's permission, he can do that, or he has the legal right to just build the sidewalk.
Okay.
Up to code. All right.
I guess on the other part...
Yeah, on the other part, I'm looking at your site plan and the proposed building, and I know you want a rear setback of 7.2, but your buildable area, tell me why you can't build in your buildable area and not go back to the setback, because you've got room on the, I see that there's it looks like well, I don't know exactly where the property is, but it looks like you have a buildable area you can easily build in.
Like pull the house further over to the...
Well, just make it more square instead of rectangle, and you're in your buildable area. So I guess I'm not sure.
I guess it was just sorry, I'm probably yelling into this. The plan that I had picked for the lot, I didn't realize that the back was a 20-foot setback at that point.
Right. Well, and I understand that too, and don't get me wrong, I understand the desire on it, but you've heard enough of this probably than you ever want to hear again from this meeting. But we got to come up with a hardship, and you've got a nice size lot, you've got a nice size buildable area, and you've got to tell us why it's impossible for you to build in that buildable area. And some people have a sewer line easement going through it. Some people may have big old trees or something. But if you don't give us a hardship that 4 of us agree with, then it's going to be really hard to say, yeah, you can do.
No, I guess the only I don't know if you would call it a hardship or not, but. What I'd presented was the fact that the lot is much shorter than the rest of the neighborhood. The standard lot in the neighborhood is about 175, and that one's only 100.
Right.
So overall size of the building for that neighborhood is not oversized in any way. It's just a matter of it being on that particular lot.
Right. So it's narrow and long instead of short and
fat. Yeah.
But it is possible, though, to build in that footprint, the buildable footprint, just not what you want to do.
I'm sure if I completely trash the plans that I have and start over, I'm sure I can come up with something, yeah.
Okay. Are there any? Yeah. So are there any questions? Did you have anything else to add? And the sidewalk issue, like I said, if we vote on what planning recommended, which is for you to keep the sidewalk and pay, you still have the option to go back and look at it and say, that's a lot cheaper for me to build up to new code. I'm just going to build up to new code. We're not requiring you to do that. It just gives you that option if that ends up being a better option for you. So if you don't have anything else to add, then we'll close the public hearing. Any thoughts?
still looking for the hardship.
Yeah, I mean, that's, it, the testimony was clear. I mean, I get that, this is what you've been building and you want to build it and the rhythm, but the buildable space is certainly there, and I don't see that. And so, I'll move that we deny the variance and that we approve the sidewalk variance with the planning department's recommendation that the applicant pay and dedicate the right-of-way, and should the applicant decide to build up the sidewalks up to code, that would be the applicant's option.
Second.
Any discussion? All in favor, say aye. Any opposed? Great, thank you, good luck.
Thanks.
Next case.
Case 2019-433, involving property at 5213 Illinois Avenue. This is a request to construct 2 single-family residences without building sidewalks or paying into the fund. Zoning map shows you the zoning of the property is R6. Aerial photography giving you a sense of the surrounding area. This is the site plan submitted by the applicant, and finally the photograph showing you the current conditions of the property. Is there anyone here in opposition to case 433? Seeing none, the appellant will have 5 minutes. Please be sure to say your name and address before making your presentation. If you'd press your microphone.
Brian Richardson, 864 Kirkwood Avenue. I'm requesting a sidewalk variance at 5213 Illinois. My hardships are I have high-intensity power lines running down the side of the property with guy wires that off-hook those power lines that come in front of the property. I've got a storm drain, a fire hydrant, and I've got a 53rd Avenue easement, which the city maintains, running down the side of the property. I've only got a 30-foot building envelope, and the property is 69-foot wide. I would just like to pay the in lieu of fee for the 30 feet that I can use instead of paying the full 69 feet. There's no way to lay a sidewalk at all.
So, yeah, so, I mean, tell me about, so your property, so you,
Yeah, so
tell me about what this
those
is.
are high-intensity power lines running down the side of the property, and also under the power lines is a 53rd Avenue North easement. It was a proposed road that was going to cut through the property. It never did, and they maintain those rights to the easement. So not only are the power lines, but there's a 53rd Avenue easement coming down through there, which only gives me a 30-foot envelope.
So it's technically your property, but it's not property that you can use.
Can't use any of it.
So you are willing to pay for the 30 feet?
Yes, sir.
Okay. That's by any person driving down the street would think, well, that's your property.
Yes, sir.
Okay. Any questions?
I don't have a question, but this is another one that I read while I was out for an hour, and the council person for this area opposed this request as well.
He opposes the, I think that, yeah, did he oppose, well, all right, do we want to talk, let me talk.
I spoke with a council member. She didn't oppose it with me.
The 30-foot, I mean, I guess it, yeah, I think the council member wanted the in lieu, but was there?
It says when a developer pays into the in lieu fee, it's not going to her district. So I'm just,
Oh, I see. Well, that may be a different objection.
We would love to lay the sidewalk because it's cheaper.
Right.
But there's no way to get around the guy wires and, I mean, everything else.
Okay.
I mean, I've got 4 or 5 public utilities on the property that keep the whole side of the property unusable.
Okay. Then, did you have anything else to add?
No, sir.
All right, then I'll close the public hearing and we can talk about,
well, if we could go back to the photos, I didn't see the power lines and, maybe
Yeah, see those guy wires coming off the power lines? There's 4 of them.
we were stuck on the other photos.
Got
so
you.
thank
And they go to the middle of the property. So actually those guy wires are going to run in front of the new houses we're building.
I was looking at a property maybe across the street.
okay.
Yeah.
All right, so I'll close the public hearing. It sounds to me, given this property, a reasonable request for paying 30 feet. Does it sound reasonable to anybody else?
I think I'd be okay with paying half of the 69 feet, which is
So
pretty
34?
close. Yeah, it's 34.
Is there any other thoughts? Is that a motion?
That's a motion.
All right, I have a motion that the variance is granted and the applicant will pay for 34 feet. of property frontage, and there's a second. Is there any other discussion?
Can we also add that the right-of-way be dedicated in the event that they fix this power line situation and
And that,
construct the sidewalk in the future?
and that the right-of-way be granted?
I'll amend the motion to include that.
And I'll amend my second.
All right. Have a motion, have a second, have an amendment. Any other discussion? All in favor, say aye. Aye. Any opposed?
Can you explain that right-of-way part?
That just means that you just dedicate the right-of-way in case the city comes in and builds a sidewalk.
Okay.
I think that usually that is part of planning's recommendation, and it most likely was part of the planning recommendation.
Got you. Thank you.
Next case, 2019-435, involving property at 430 Haney Avenue. This is a request for variance from sidewalk requirements in order to construct a warehouse without building sidewalks or paying into the sidewalk fund. Before you use the zoning map showing the zoning of the property is IWD. Aerial photography giving you a sense of the surrounding area. This is the site plan submitted by the applicant, and finally, the photograph showing you the current conditions of the property as well as up and down the street. Is there anyone here in opposition to case 435? Seeing none, the appellant will have 5 minutes. Please be sure to identify yourself by name and address before making your presentation.
I just want to introduce myself. My name is Ashley Upkins. I'm legal counsel for Bell Group and Derek Bell.
My name is Paula Hepp, 209 10th Avenue South, Nashville. Representing the client also in this case. We are the engineering firm for the Haney Industrial Warehouse that's going in. So we started this project a year ago, did all of our due diligence, and just to, I know you have our packet, but we did all of our due diligence and went through the process. We spoke to several departments at the city, and the computer showed that there was no sidewalk due and no fee in lieu of due for this property. We moved forward. We didn't try to get away with anything here. We did our due diligence and we went forward. 2 days before pulling the building permit, the computer was changed to show that all of a sudden sidewalk or fee was due. Our client had already done his pro forma and gotten his bank financing, and all of a sudden there was a $52,000 fee that was due on the property. We're here today because Haney Avenue, and Councilwoman Toombs did come and speak, and we appreciated much earlier today.
Yes.
Sorry. But she did come and speak to it, and she understands what's going on here. Haney Avenue is a residential street that is being turned over into an industrial development, and the community plan for this area is industrial. It's going to be all industrial at some point. The property itself has a condition with a steep slope on a large portion of the property with a guardrail on it. To shorten this, what we're speaking of here, Councilwoman Toombs talked about a fee to be paid. Our client is willing to help to pay for the pedestrian fund, but the frontage, the 350 feet of frontage, over half of that can't really be built, sidewalk really can't be built because of the guardrail that's there. So we would be proposing about 115 feet of that property would come from the east up to the driveway for his industrial warehouse development.
So you're proposing that you'd like to pay for a third of the
115 feet of that, which I think comes out to $17,491. He understands that he's trying to be a good neighbor, but realizing that the dead end of Haney, there's going to be really nobody walking past his property in the end. So we'll go ahead and pay a fee for what could have been put there up to the driveway.
Any questions?
I just want to add, just so we have it on record, that Councilwoman Toombs, we did mention that she came by, but she was mostly in favor of some lesser fee. I think the issue is, and I just want to make sure it's clear, the amount of due diligence that was done to make sure that there was no fee, and so to later on find out that there's suddenly a $52,000 fee for a small business owner. is certainly, I would hold as a hardship because he did in fact follow guidelines and rely on the information that he was provided.
The number of fee you're willing to pay for, did you say 100 or 120?
It was 115
feet.
Okay.
115 feet gets us to our designed driveway access point. And then right after that is where the guardrail basically starts and the steepness of the drop-off from the road.
Questions? All right. Anything else to add?
No, sir.
I'll close the public hearing. I do have, I mean, we're still in that kind of gray area with the zoning administrator in the waiver process, and at some point, the waiver process will allow the zoning administrator and planning to negotiate this type of thing, and then they come to us if we disagree. So I do have a question to you. Were this to be a waiver request instead of a variance request to us, does this proposal sound reasonable and something that you would probably, I mean, I'm sure, because ultimately, I mean, to me, it sounds reasonable, and it sounds, and frankly, I mean, I think it sounds generous, given this, the location of this site.
Sure. We look at the same types of factors that the board reviews because it's the same applicable law. So we're looking at the same kinds of things with the topography of the lot at the western edge as you move toward the dead end, the fact that it is a dead end, the fact that it's industrial zoning being used for industrial use, and the fact that although there is no sidewalk present, that's not a criteria that means yes or no on whether or not the sidewalk law applies. The reality is if Metro were to build out in the future, they would never need to build out past this driveway because nobody would have any business going farther west than the driveway of this last business on the street, realistically. So those are the kind of criteria that we would take into consideration and have thus far in the early days of the waiver review process. It just so happens that the filing date for this particular case meant that it would necessarily go through the process here at BZA rather than scrapping it, starting over, going through our newly created waiver process.
So it would be, had they applied a week later or 2 weeks or whatever in that new time frame, this would most likely be something that you would consider acceptable.
Absolutely, the whole group would, and it's generally consistent with some of the things we've seen even now with commercial projects.
Okay. I just wanted to, as we're in that limbo period, I just want to make sure that we're that I'm looking at it in a way that reflects how it's going to be looked at down the road. Well, I'll move that we approve the variance and provided that the applicant pay the in lieu fee for 115 feet.
I'll second it.
As a motion, I have a second. Is there other additional comments? I'm sorry.
I'm sorry, sir. There was a comment from, I want to say Ms. Lamb, in an email about dedication of right-of-way for this property. There is 50 feet of platted right-of-way already for this property, and if the sidewalks were to be constructed, there's enough room within that 50 feet for them to be placed.
So there's no
I just wanted to make sure that that didn't get overlooked because that was a planning staff comment about the dedication of right-of-way. So I just want to make sure that we're taking care of that.
So the right-of-way is dedicated as part of that?
It's already there.
Okay.
All of it is?
Well, I think there's a 50-foot, right?
Yeah.
So that would be more than enough.
That was an email, I believe, that you sent to me. Is that
Right,
correct?
from the
Yeah.
planning staff comment.
Correct. I did not include that in the board packet because I didn't understand it was to be directed to the board, but I did receive an email that said that the existing right-of-way is 50 feet, so they opposed dedicating more right-of-way.
Because there would be no need, because it would clearly end up for a sidewalk. Okay. So then,
Thank you.
Then the motion is to approve the variance with 115 feet of in lieu. And it was seconded. Any other discussion? All in favor, say aye. Any opposed? That motion passes. Good luck.
Thank you very much.
Peace.
Next case is case 2019-441. This is involving property at 4483 Heath Road. This is a request for a special exception in order to operate a rural, which is a hard word to say, bed and breakfast homestay. There was opposition here earlier. Is the opposition still here? Yes. So each side will have 10 minutes to make your presentation. Before the board now is a zoning map showing the zoning of the property as AR2A.
Aerial photography showing you the property and surrounding area. This is the site plan of the proposed bed and breakfast. And finally, the current conditions of the property. So each side will have 10 minutes. That's a cumulative 10 minutes. If the applicant would like to reserve any rebuttal time, that comes out of your initial 10 minutes. And be sure to identify yourself by name and address, please.
And can we get just a really quick overview of, I'd ask when we were talking about this as a potential consent item, what the difference between a rural bed and breakfast homestay and an Airbnb, owner occupied is. And I think the response was, you actually can serve breakfast, and you can't do that at a owner-occupied Airbnb. But can we also tell us what it is they're asking for and how we need to evaluate this? I know
Certainly. So that is certainly one of the differences between an Airbnb or Airbnb short-term rental and an actual bed and breakfast is that you cannot serve food at a short-term rental. This is a special exception request, which is different from the typical or more common variance requests that you hear. There's no burden to prove a hardship here. Special exception sets forth criteria that the applicant must prove in order to have their special exception granted. If the board, but that's not something that the code staff can determine administratively. That's something that the board has to walk through and determine that they meet all those requirements. If the board determines that they do meet all those criteria, the board is legally, I think, obligated to grant the special exception. The special exception requirements for a bed and breakfast are found in 1716-170, and I can give you a brief overview of those. Let me find this. $160, I'm sorry, I said 170. So a bed and breakfast, it has to be on an agriculturally zoned lot that contains 5 or more acres. It must be owner occupied, must be the permanent residence of the owner. There should be no more than one off-street parking space provided for each, no more than one off-street parking space is provided for each guest room. No signs for advertisement are permitted, and the bulk regs of the district for residents apply. So that would be the setback and other bulk regs that would apply to a residence apply to the home bed and breakfast. The owner must maintain and make available a guest register for each calendar year to the zoning administrator. Meal service is restricted to overnight guests only. Fire marshal must approve the structure for safety. So if you all determine through this hearing that the applicant meets all of those requirements, you'll be legally, I think, required to grant this special exception. Of course, the burden is on the applicant, I think, to prove that they meet those requirements, and the opposition can certainly make whatever statements they want to rebut that.
not a community impact. I mean, on some of the special exceptions, there's a community.
There's a board rule that a neighborhood meeting must take place. That's not a Metro code requirement, but there is a board rule that says for any special exception, there must be a neighborhood meeting. Was there a neighborhood meeting here?
Yes, there was.
Okay, and then, but I think there are some that.
There are also general criteria. There can't be a negative impact on the surrounding area, and you'll have to give me a second to look that up. Those are different. Thank you. So 1740-150. Nope, 1716-150.
16.
Talks about the general requirements, and that is that complies with the applicable regulations of the code. It must maintain the integrity of adjacent areas, be architecturally compatible with surrounding areas. Special exception uses in residentially zoned districts must comply with the non-residential tree protection regulations. Features of historical significance shall not be adversely affected, and there should be a demonstration that the proposed use will not adversely affect the safety and convenience of vehicular and pedestrian circulation in the area.
May I ask, so as I understood your previous statement, if those 8 criteria are met to our satisfaction, and then the additional ones that you've just illuminated or provided us, then there isn't a whole lot of wiggle room.
Correct.
Okay. If you would state your name, address, and tell us why you're here.
And good afternoon. My name is James Jeffrey Adams. I'm at 4483 Heath Road in Nashville, Tennessee. I'm here to ask for an exception for a rural bed and breakfast homestay. It's a unique homestay. It's a unique exception in the fact that you can only have 3 rooms available to the public. We do only have 3 rooms available. They each have to be unique, and they are. We also are about 200 feet off the road. If you're able to go back to the picture beforehand, please, and show that that deep, you don't even see our home, actually. You do see the sign that we're required to put up for zoning, but also our home is hidden back there. We are owner-occupied also. We will not have any kind of management of the home. It's our home. It's where we live. I'm also a chef on the side, and so I enjoy serving gourmet breakfasts to folks, and it's one of the key things about our ability to have this kind of a business on our property. Our property meets the number 1 criteria in the zoning that it contains 5 or more acres. We have 8.46 acres in an AR2A zone. We are owner-occupied. It is our sole permanent residence as well, so we have no other vacation homes or anywhere else to go. As we all are very familiar with the Airbnbs and the short-term rentals, several things that don't apply with us. One is that we never hand the keys over. Again, it's owner-occupied. We're high customer service, so we spend a lot of attention as opposed to just give them the key and give them back when they leave. Big difference there, as well as we're able to have breakfast as well. We do have a 3-car garage, which means that we have 3 parking spots in our drive of a 200-foot-long driveway. In that area, since we have only 3 bedrooms, we restrict each bedroom to 2 occupants at all times, no exceptions. That means there will always only be the maximum of 3 vehicles. As it relates to no signs, we have not had a sign, nor will we. Bulk regulations of the district for the residents shall apply. We intend to comply with all regulations and have no reason to not have to do so. Number 6, the owner shall maintain and make available to the zoning administrator a guest register. We will obviously do that through not only a guest register, but we'll have proper business books to prove, both from an IRS perspective as well as from a UNO perspective, when guests were here, what they paid, and so forth throughout the year. Meal service will be restricted to overnight guests only, of course. We do not have any other cooking facilities within the facility at the house, only one, and that's our main one. There is what we'd call a kitchenette in one of the suites, which basically is just a nice refrigerator, a buffet, and a coffee service. And of course, number 8, Metro Marshal approval of the structure. We have contacted and set up appointment for inspection. However, we do also have 10 fire alarms in the house. So we believe that we do, based under Title 17, 16, 160A, comply with all Metro codes of laws and zoning ordinances. We also went through all the strict regulations as to how to get to this point in doing our due diligence, including having a community meeting on September the 15th of 2019, where Mr. Dave Rosenberg, District 35 Metro Council member, was in attendance. And I believe if you'll look at the package, you'll probably see where he approved, excitedly, to us anyway, of the property.
Yeah, we do have a letter of support from the council member in our packet.
Thank you. On that day on September 15th, we were giving a packet of 15 addresses that were supposedly 600 feet away from our property. 15 addresses. Now, this is a large property. It's 8.46 acres. Every property in the entire area of Heath Road and Deer Ridge has to be, by a 1974 ruling, 2 acres. I think all of them are over, around 2. I think some might have been split up, but ours is much larger. We do not even, from our home to the one to the left of us is 300 feet, and the one to the right of us is 200 feet as a crow flies, through dense woodland areas. If you'll do the overhead of the property, please. You'll see there, ours is that pond in the very back. That's our pond. That's our home. You'll see then to the left, the next home. And to the left, past to the right top, is another home. Again, through 12 months of dense woodlands.
So you sent out all the letters to everybody, and then how'd your public meeting go?
2 people showed up out of the 15, including Mr. Ronald Hooper, who lives next door, and Miss Bonnie Jones, who lives up on the hill even beyond. No one else showed up. We did speak to a couple other folks, and there is some opposition obviously behind me. There was also some folks that was rooting us on, including Julie Kornman and Steve Mitchell from 4500 Heath Road, about 2 doors down. We also had Bonita Young at 4438 Heath Road, also approve. Bonnie Jones, who I mentioned earlier, who did come to that meeting at 4533 Heath Road, also approved. And then Larry and Deborah Campbell on Deer Ridge had an opinion about it. So I say all that because of the letters, because I think there is some upset neighbors, and rightly so. One is because when we started doing our due diligence, we thought we had to go down the route of a short-term rental agreement type thing, because we did not know there was this piece of it here. And so that because all of Nashville was kind of going through that, we thought that was the path we had to go until we realized that we actually was part of this homestead exemption. And so right before that we were having our meeting on the 15th, my wife and I also went to neighbors that were in our general vicinity, just in the 5 or 6 right there beside us, and hand-delivered in the mailbox additional letters so they would at least be notified. But because these properties are anywhere from 5 to 8 acres in depth, if you will, or in size, many of the neighbors did not get letters. And so they never knew it. And I think one of the big issues is the fact that this is a small community, big properties, but small community, and the traffic would cause some issues. Well, in this day and time, we don't do much shopping at Target, Walmart, or any of those places else. We use Amazon. And actually, we get probably 3 to 5 trucks coming to our house a day from Amazon, from UPS, FedEx, or the post office, delivering things. So we have a lot of traffic into our property often. So 3 cars potentially, that's if you're 100% occupancy, which is very rare in any kind of bed and breakfast. It's usually 40 to 50% occupancy rate across the year. Then we might expect 1.5 to 2 cars. And because we also have full-time careers, this is mostly a weekend hobby business for us as well. So we enjoy that, enjoy cooking, enjoy having folks stay with us, enjoy learning about people from other parts of the country and staying with us. So that is why we're here today. That's a dream and goal we've had for many years. And I'll yield it back to you.
All right, any questions? All right, you'll have a minute and 28 seconds for rebuttal after we hear from your neighbors.
All right.
Hear from the opposition. I know you have 10 minutes total, and that's for everybody who'd like to speak. If you would just press the button and make sure the red light's on and state your name and address and tell us your thoughts.
My name is Ron Hooper. I reside at 4463 Heath Road. I'm the property next door. We have 5 acres there, and I'm here to voice my opposition to a exception being granted for you to allow a commercial establishment in what is otherwise a residential neighborhood. As he stated, this is a small community, one way in, one way out. So there is concern about traffic on the road. Now I'm going to let other people who are here talk.
I'm Duffy Schultz. I live at 4606 Heath Road. I've been up there for 27 years. The problem I've got with this, you changed my zoning. I've sat in here and realize now how much a special exception creates problems. We've got a nice, simple neighborhood. I just seen you didn't change my zoning. And that's really about it.
Yeah, and I mean, and we're here, I mean, the rules allow this applicant to, because you're in an agricultural district and the criteria that we've already talked about, the rules allow this any property owner to apply for this special exception. It doesn't change anybody else's zoning, and it
Well,
basically
that's what you
just,
say. But when you open that Pandora's box, then who knows what? And, we're asking, I understand listening to the rules and regulations that we've got to have fire protection. We don't have fire hydrants up there. I know that for a fact. I've been there 27 years. We have clean-out hydrants on the road, but there is no water supply up there for a fire truck to pull up and hook a hose up to.
So let me ask you this, sir. You heard from, and I'm going to say this for all the neighbors so that you heard from the zoning staff that when you apply for a special exception, if you meet all the criteria, then we're required.
Understood. I understand that. I understand that.
But here's my question, though. The area of this criteria that I think you all can speak to is any impact it has on the surrounding area, the integrity of the neighborhood, and that type of thing, which are certainly things to consider. And know that, that safety concerns and that type of thing, they have to go through other boards besides us. We can't say it's going to be safe or not safe.
I understand, but I'm here to give my opinion.
And I'm not.
The next question for you is, what if he decides to sell this piece of property? Does this exemption go with it, or is it him only? Or does it only go with the owner that it's issued to?
Yeah, I think any special exception runs with the land, and so a future owner.
Okay, well then, I got a problem.
A future owner could, but now again, with the same restrictions, 3 bedrooms, with all the restrictions that were said, and if the criteria changed.
So if he had this piece of property listed for sale right now, it would have no impact whatsoever on your decision. That's wrong. Thank you for your time. Thank you very much.
It's for sale right now. Listed last week.
Hello, my name is Tammy Kaiser. I reside at 4620 Heath Road. We learned about this on Monday evening, and an email was sent to us. We never received a letter prior. We never received an invite to the community meeting whenever they held this originally. So Monday, other than the sign that was out front, was the first that we heard of exactly what they were wanting to do at this property. We do have one way in, one way out. There is a great deal of traffic. They do have off-street parking, but it's a narrow driveway that leads to their house. And their house was listed for sale on 9/27. So it really causes confusion as to why they're going to this hearing and trying to get the bed and breakfast whenever they have the house listed for sale as of 9/27. It is not beneficial for the neighborhood. It's not beneficial for anyone in it other than the homeowners. Thank you.
And ma'am, do you live closer? You said one way in and one way out. Do you live closer to the way out, or do you live further back?
I live further back, so I have to pass the property in order to get out.
And so the sign is supposed to be up for 30 days before the hearing. Did you not notice the sign, or was it?
I did not see it 30 days before the hearing, no.
Okay. Is that?
And I took a picture of it. I had my daughter take a picture of it the day that we did notice it was up, because immediately I thought, oh gosh, that house is for sale again, because they purchased it a little over 18 months ago. So I thought it was a for sale sign. And, on a street with 17 houses, you notice everything in the neighborhood. So immediately we stopped to see what the sign said, and that's when it said it was a variance for the bed and breakfast.
Okay.
But no letter. We received no letter and no invite to the community meeting.
Okay. And, okay.
I have a question. You said something about parking on the street. Can you clarify that?
There is no parking off-street. I mean, there's only parking down their narrow driveway or in front of their home. There's no off-street parking on the road. No one would be able to pass on the road if anyone parks on the street, or they'd have to park in the grass or on the easeway. There's no off-street parking on the road.
Are you observing that people are parking off the street?
There are, and I don't know exactly which home it's happening at, but there are, when you enter onto the road off of 70 South, there are at times many cars that are pulled at the side of the road that inhibits, and it's a windy, steep road, so it's not just a straight shot to the top of the hill to where my home is. It's windy, and it's a very steep incline to that.
Good afternoon. My name is Behnush Sadri. I live at 4601 Heath Road. Almost 30 years ago, when we spotted this land for sale, we considered ourselves lucky, and we loved building our dream house on that because of, first, the peaceful environment, and second, because of the neighbors who are very family-oriented. Having a Airbnb, or as they are advertising it on their site as an inn, it's horrible for us. We are 2 doors down from this neighbor, and we never heard anything about a community meeting. We never received a letter, and it may be 8,000 square feet or 5,000 or whatever, but on the sides, the homes are close to each other. It's not that far away. And across the street, the homes are close to each other, so it's not that far away again. Having something like that, an inn, as they advertise it on their site, is really scary. My husband and I were notified 2 days ago. Actually, it was to him by an email that a neighbor is running an inn in their house, and we were outraged when we realized that it has actually been operating in starting 2017, 2 years ago. And the other problem is...
So you're saying that they were...
if you go to their site,
I have the copy of everything.
All right.
The start of there is
Sir, could you tell me your name and tell me?
My name is Mehdi Sadri.
And I press the button and make sure the red light's on.
Okay.
There you go. Sorry.
Sorry about that.
Yeah.
Okay. My name is Mehdi Sadri. I live at 4601 Heath Road, 2 houses from them. And she's my wife.
Okay, but you had something you wanted to show us, so that's...
Yeah.
She'll get that to us and make that part of the record.
Should I go on? There are very nice houses in our neighborhood, and they are all like 5, 10, or 15,000 acres of property. And the other concern is the decrease in our property value. If someone want to pay the price and go to a quiet neighborhood and live in a nice neighborhood, there is no way for them to do that with the bed and breakfast or an inn down the road. So we are concerned about the decrease of the property in our neighborhood. There has been an increase in the cars driving up and down the road. We have noticed that, and we were wondering about why, because we had no clue about what they were doing down the road. The residents walk on those roads all the time, day and in the evening, and the road is very narrow. It's hard for two cars to pass by each other, and because we've been living on that road for many years, we are careful. And for newcomers and for the people who just are vacationing a few days, that causes a concern of safety for the neighbors and for our properties, the cars that go back and forth. My house is on the corner of Heath Road and Deer Ridge, and therefore all the cars who want to turn around, they get on my lawn and they have damaged our lawn time and time again. At the end, I just like to express my concern about how threatened I feel, knowing that strangers are going to be walking, wandering in my neighborhood, on my road, and around my house when I don't know them, and they can be of any background from anywhere.
So did you have, the opposition has 1 minute and 45 seconds to add anything else they'd like to add, so.
I don't, but my husband does.
I add 2 more points. Our area, they put a water line many years ago just for a few houses. And the water line running that place is only 3-inch. And this 3-inch, most houses at top of Heath Road has a pressure problem because 3-inch is not enough for that many houses that area. We contact the Harpeth Valley Utility District. They serve in that area many years ago, and we have a meeting with them. They said they saw at least they need 8-inch line to everybody get the right pressure. And they said they are working on it, and still they are not doing anything. One of the problems, they don't have enough budget because they have to put the bigger tank that area. And right now they have only 100,000 gallon tank at that area, and if they put the 8-inch line, they cannot fill up the water that area. And other problem is if the people come in, stay for breakfast and lunch, for bed and breakfast, they're using a lot of water, and every time everybody using water, the other top Heath Road doesn't have no water, doesn't have enough water. The pressure is get very low. And this is something, I don't know what we can do with this problem. And other problem, our area, as another guy said before, we don't have no fire protection because every hydrant is that area is on 3-inch line, and they are not can't use it for they're just using for flushing. It's not for fire. And this is the picture I have for fire on this area.
Okay. And sir, our time is up, but let me ask you,
and this is the policy they have for the fire hydrant that area.
Okay, and if you give that to Jessica, then we'll do that. But I just want to make sure that and our time is up for the opposition, but I do want to make sure that I ask, so your testimony was that because of the water, that one of the negative impacts of greater density on your street is that the water pressure is affected by more people.
Exactly,
okay.
Exactly. And this is one, and other things, few years ago, one house is burning out completely. And the fire hydrant cannot do anything because there is no fire hydrant over there.
Okay, great. Thank you.
Exactly, that house was from today
right.
house.
Exactly. And our time is up, but I appreciate your comments. And so we have the applicant has, I'm not sure how much time. 1 minute, 28 seconds for rebuttal.
Thank you.
So I guess the two quick questions. One is the opposition gave information about an Apoda Inn. Is that your inn?
It is.
And so you all, I guess, were renting your home as for Airbnb and?
No, sir. We got married in 2017. That's why it's called 2017.
Okay, but it says, I guess there's 58 reviews. Oh, no, that's somebody else. So you didn't rent your?
Yes, we actually, let me explain that a little bit better.
Been running it.
Let me explain that.
And let the applicant answer. We ask him a question, it's for him to answer, and they need everybody else to let him answer and be quiet.
Thank you. So we have been, prior to actually this date, we have been inviting on Facebook, we have been advertising to our friends and family. And so we did do a pilot program where we had friends and family come and spend the night with us, enjoy the scene, enjoy the items. We didn't charge, but we fed them breakfast and gave them, so they could give us some feedback too.
Okay.
So that's the reason why for that.
So you never took money for?
No, sir, no.
And then, are you selling your house?
If this does not go well, we were, absolutely. Mm-hmm.
But I mean,
we also understand that we are not able to transfer this business and this exception to anyone.
Well, that's not true. That's not what
Can we get a final on that, please? Because
no, we already have.
Really?
We asked this while you were up here before, and all three folks said it went with the land.
Okay. Okay.
Not that it would take any more than one of them, but it was actually unanimous.
Okay, all right.
So, but now, and your neighbors had said, that you were selling your property, or you said you were thinking about it, but, and so I thought, well, in the computer age, it's listed on Zillow and has an open house on Sunday.
That's correct. Mm-hmm. Absolutely. And that's because we didn't know what was going to happen today, quite frankly. We had no idea. Obviously, we knew we had a lot of opposition against us. And so this is why we have it. We're two people in 5,700 square feet. We don't need that unless we can run it as a business. So our kids moved out, so that answers the question about the water. We've had water and people using that for 30 years in that same house, so that hasn't changed any. We're 1 mile from a firehouse, not a fire hydrant. We're less than a mile from a firehouse in Bellevue. We're not making any changes, obviously, to the coding, to the zoning. There is no parking on the street for us. We never have. We've never increased any of the traffic because we haven't had this as a business for people coming in yet. And of course, we have a septic system that allows for 4 bedrooms as well. So that's what we have. So we won't have any impact. We're not changing anything structurally. We're not cutting down a tree or a branch. We're not adding anything different. It's our existing home, the existing parking, and no impact on the environmentals.
Mr. Chairman, I have 2 questions. All right. In your application, you said that you have an appointment set with Metro Fire to come and inspect the property.
Yes, sir.
That's correct. Okay. But yet you're already having guests in there prior to their
for friends and family. So it's like if you had your son or daughter at your house this weekend.
Well, okay, but
yes.
And then when did the kids leave?
My daughter just started WKU in September.
Okay. So you've had 3 kids in the dwelling for the last couple of years?
On and off, yes, sir. We have 3 daughters, and they would come and and stay with us for different summer and so forth. And they're all 3 are in college.
Okay.
Yeah. That's a lot of water.
Any other questions? Did you have anything else to add?
I believe not, no, sir. Okay. I think I've covered my notes.
All right, we'll close the public hearing.
I have a question for the zoning administrator. So if the special exception is approved, it won't issue until there's a fire marshal approval, correct?
Correct. Necessarily, there's the U&O permit at the end of the process, the use and occupancy, and a condition on that will be approval of all the required agencies. Just one that we specifically have itemized here in the zoning code is the fire marshal's sign-off. That's pretty consistent with anything that's kind of in any way a commercial lodging, no matter how small.
So again, I'm going to go back to my same question I asked Emily a little earlier. They meet all 8 criteria. We don't have a whole lot of wiggle room, do we?
Well, the 8 criteria is under the specific language for this particular special exception, or the old lawyer phrase, I guess, conditional use permit. If they meet the conditions, then the permit. And then the general criteria under 150. The things that the board typically looks at is that language about integrity to adjacent areas. unless there's a demonstration by a testimony or other demonstrable proof before you today, there would be a detrimental impact to neighboring properties or area properties that would render the uses of those lands no longer valid uses, i.e. I can't live there anymore, then yeah, if they demonstrate all those things with their application, you don't have the option to not grant
But
the
the negative
special
impact
exception.
is pretty broad, though, right?
It is.
Because, and you know, the thing that, you know, the neighbors brought up that, you know, is a concern for me is, and it is, you know, the fact that the house is actively for sale with an open house planned Sunday. And so it's not just on the market, it's being actively marketed, which to me raises a little bit of an issue on the owner-occupied point requirement. And it also, I think, raises some credibility to the negative impact in terms of what are you getting, you know? I mean, and I think folks have a right to know what they're going to get. And I'm disappointed that that had to come out from the opposition, especially since it's such a public, it was easy to find on Zillow while we were talking.
And also, to that point, it's sort of hard to review the evidence that's been submitted in support of this and then hear opposition evidence that's just as credible. Because now, as I weigh the evidence, the applicant said that, you know, they had friends and family come stay at their place, but the fact that there's a Yelp ad that's calls it an inn, like, that doesn't sound like if I'm inviting friends and family, why do I have a Yelp ad? So I just think there's a lot of like contradictory evidence that's in the public forum that doesn't really line up as this being a special exception. And then also, I think the neighbors presented a really compelling argument on maintaining the integrity of surrounding areas. This is a very small rural, it's hard to say rural, community, and to have this type of commercial activity in that area, I think does impact the integrity of that neighborhood. So that's kind of where I'm at.
I mean, you can second guess it. You can, you know, if we want to consider that they were not truthful in their application, because they have been, in point of fact, commercially renting it, we may have the wiggle room. But right now, if they meet the criteria, I'm having a tough time interposing. Yes, ma'am, please. Jump right in here.
So just wanted to review a couple of other criteria. John Michael and Emily have done a fantastic job of outlining those boxes that you have to check off in order to meet that. But here's the burden of proof. The 1716-150 says that the burden of proof is a special exception permit shall not be considered an entitlement and shall be granted by the Board of Zoning Appeals only after the applicant has demonstrated to the satisfaction of the board that all of the standards, that's their general standards and the specific standards, have been met. So your question is not necessarily what have they not shown, but what have they shown? And have they met their burden? Okay, so that's the question before the board. Have they met their burden under all of these criteria? And if they had met their burden under that criteria, then it would follow, as John Michael and Emily have already stated, that the board's approval would follow. However, if you're going through this criteria and you see where they have not, then that's your standard by which, if you so choose, in your discretion, it's your decision to not grant it.
And I think
I think you have to go through the criteria.
And I think that's probably why you have, you know, planning will come out and recommend something, because on their take, you know, in terms of those criteria, agriculture, yes, it looks owner-occupied, but they don't evaluate it from neighborhood impact. They don't evaluate it from a general perspective. And so that is, to me, that is where the question is at this point, because I think on the specifics, it certainly qualifies if they meet the other.
With the exception of the fire marshal.
Well, and again, and that's,
Yeah, that's the only
exactly
one.
right, and that's not our purview, and that, you know what I'm saying, that
Well,
they-
if you just go
Right.
through the 8 criteria listed, and that's what I keep coming back to, and I'm not letting it go, I guess, and maybe I should, because we do have a lot of folks in the neighborhood that are going, not no, but heck no, we don't want them to do this. I'm very concerned, and I don't mind saying this, that this will run with the land.
Oh,
Oh, good, please.
thank you. You reminded me of something else I was going to mention.
Yes,
So, yes, it does, the permits do run with the land. However, you can impose conditions. And the zoning code under 150J says special conditions, notwithstanding a finding by the Board of Zoning Appeals that a special exception satisfies the minimum development standards of this article. The board may restrict the hours of operation, establish permit expiration dates, require extraordinary setbacks, or impose other reasonable conditions necessary to protect the health, safety, and welfare. And what we've seen before in these kinds of cases is an expiration date. So it runs with the land, but you can put an expiration date on the permit that you issue today, such that anyone else who takes it or takes the land subject to the permit, or even the applicant, would have to come back before this board and have the permit reissued if you put it on a year or if you put it on 2 years or whatnot. So technically it runs with the land, but you can impose some conditions that have been reasonable. Expiration dates have been deemed reasonable.
So we could almost have it run like a life estate for as long as these individuals were the owners.
Now, you basically have to say, we'll give you, no, you can say we'll give you a 1-year permit, a 3-year permit, a 5-year permit, or there's no restriction at all. I mean, it doesn't have to be 1 through 5, but you can.
But I know what you mean, yeah.
You can say.
We can't limit it to just this owner.
Life estate's getting a little bit.
I know, I was using a technical phrase, but I'm trying to limit it to the applicant.
But in this case, even if which I'm not ready to concede that, but if I concede that they've met the requirements of a special exception, I don't think they've met the requirements under the general standard. I think we have to take the applicant's testimony at their word. And in this case, I heard testimony that said this was their life dream because he's a chef on the side and they want to have this done. And then I find out it's for sale. I'm not getting and then I have a bunch of neighbors who showed up who said all this stuff about their integrity of their neighborhood, and that standard, they have not met that standard from my perspective. If I give you the specific standard, I can't give you the general, because I think the integrity of that neighborhood I think that's at least from my perspective, it's super compelling, and I think this is essentially a commercial activity that might have been running illegally for the last 2 years.
May I add anything at all? No.
The public hearing is closed.
Well,
Oh.
so
Anybody else at this point?
I think that they have, the explanation that they have, I mean, there's no requirement in the special exception that your property not be for sale to get a special exception. I think that their explanation about putting their property up for sale because they want their options is perfectly plausible. I don't have any problem with that. They have the right to do that. I don't think that they have been engaged in commercial activity because they didn't take any money for this. I think they were trying to, see if this business would work, and it comes across as a commercial activity, but I think that goes away when they tell us that they didn't take money for it. I'm with you. They have met all of our job in these special exceptions is, I think it's easier than it is with variances, because if they meet the requirements, it's granted, and I think they've met all 8. I don't think that, I think they've also met the general requirements. I understand that the neighbors aren't, it's going to be something new and different, but it's not a hotel. There are certain restrictions. There's a limited number of rooms. There's a lot of buffer in this area. I could imagine people coming in and staying the weekend and any adjoining properties ever knowing they were there, ever seeing them. So again, yeah, I feel like in these special exceptions, my hands are somewhat tied. I don't really get to determine whether it's even something that, is good or bad. It's, do they meet these criteria? And I understand the neighbors' concerns, and I think you're focused on that. And but I don't think that those rise to the level of convincing me that their property is going to be depreciated, if there's going to be some real significant problem. So that's where I am on it.
Well, I agree with you, regrettably agree, because we do have a lot of opposition, and I understand that. And but I think our hands are tied as well. And I think we can impose some conditions. For example, the off-street parking, that they don't park along the street. We could impose conditions that, limit the time, I guess not the time of operation because it's an overnight stay, but we can put reasonable conditions on the permit. I would prefer that they come with conditions and things that they have said in writing, so we're not doing it. And that's where I am right now.
I'm with Ashanti.
The only other thing that I would say is we could limit the term maybe to a 1 year and make them come back. And it may be that folks in the neighborhood don't have a problem, but then they may be.
I'm not going to support that motion.
Okay.
So
Yeah, no, we haven't got
so is there a motion anyone would care to make?
I make a motion that we approve, subject to no off-street parking. Having met the criteria, I really don't see that again, we're under the general, so, and I disagree with Shanti on this one, but, and that, what other reasonable restrictions can we put on? I mean, I'd love to have a 1 year, but.
So your motion is for a 1 year?
It is for a 1 year. I'm just going to go with 1 year and let them come back. I mean, now they know they mess it up. I'm going to be listening to the neighbors a whole lot.
Okay, so there's a motion to approve the special exception with the condition that the permit, no off-street parking, and that the applicant would have to reapply in 1 year. Is there a second to that motion? Second. There's a motion, there's a second. Is there any discussion? All in favor of that motion, say aye and raise your hand. And those opposed, that motion receives three. Yeah, that motion receives 3 votes. I'll make a motion that the criteria for the special exception have not been met, and that we should deny the special exception.
A second.
And that as a second. So those in favor of that motion, raise your hand. And all opposed to that, raise your hand. So that motion fails to receive 4 votes. So there's 2 motions out there. By board rule, for any motion to pass, it has to have 4 votes. This case will stay open for 30 days. The people that, the 2 members who are on our board who were not here can review the tape. If it fails to get 4 votes within 30 days, it fails by matter of law. If the 2 members are able to review the tape, then they can participate in a vote at the next meeting. And I believe that's it for today.
That's it. We'll lose a quorum at this
We will
point.
adjourn and hear the remaining cases at the next meeting.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information about this and other programs, visit nashville.gov.